My lord. After Simple.
There is a skill diary was called for, Lordship. The petitioner is in custody.
Case that he has not received today, my lord. Arrested on 7/11. Arrested on 7/11.
7/11 and as on today 59 days. Lordship,
What is the allegation?
allegation of dowry death, Lordship. That wife died and subsequently brother of his wife lost the present case, alleging that there was dowry demand, and now he suspects that because of that dowry demand, his sister has been killed.
Sri Bhumi case.
Sri
Let us try within this week. Take one date before vacation.
Then on the 8th, my lord.
8. The case diary is not yet received. Stop. The petitioner was arrested on 7/11/2025. Issue fresh requisition, fix on 8/1.
Lordship, present 84 days behind the lordship. Opposition first 109 lordship. Allegation is physically assault the informant victim. Diary was called for.
Case diary not received, my lord.
84 days from the detention period lordship. 84 days again to the lordship.
Please also let us fix it on for 8 only.
8.
Kamalpur. Case diary is not, I got no order. The date of arrest is 13/10.
I think the lordship.
Kamalpur PS 123 of 25. 8.
Lordship.
Case diary not received, Lordship. Final complaint is going to be filed day after tomorrow, Lordship.
NCB is there. Okay, so
Second time mail.
yes, yes, no issues. So case diary is not received.
Not received, Lordship.
And, final complaint.
It's going to be,
Charge sheet,
Lordship,
charge
charge sheet is going to be filed day after tomorrow.
So when should we fix it?
Lordship, Friday, Lordship.
Friday, last day. The case diary is not yet received. Still. It is, can I record that submission? The
Lot-
final complaint.
lot-
It's also Ms. Vika, Learned Counsel for the NCB, class prosecuting agency. Submits that the final complaint / charge sheet is also likely to be filed in a day or two. Issue fresh requisition for the case diary, and along with the charge sheet, you can bring.
Lordship.
And if in the meantime charge sheet is submitted, a copy of the same, scanned copy of the same, shall also be sent. Please the matter on 9.
Is it, yes, Lordship.
9.
Lordship.
9/1.
Highly obliged.
31.
Satya, my lord, we have got the information that charge sheet has already been submitted, my lord.
Confirm. Charge sheet is submitted. Oh, doctor, medicine, no? Indrajit Roy. He is in custody since 3/11. You can this
Since 3/11.
face trial. No, can be. Otherwise, falsely representing as a doctor. There's some dispute.
Whether, my lord,
qualification.
whether, my lord, he is still in custody or not, my lord.
Oh,
No, they have
he
not
must be in custody because nobody has appeared.
Nobody has appeared, madam.
You think that he maybe have been given default bail?
Maybe,
In the
madam.
meantime.
Maybe, madam. That is
I see. Then I can,
28,
there
31.
cannot be two bail orders.
Yes, today is my lord almost 64 days, my lord.
64 days.
Today.
Then it was 60-day offense. 60-day offense.
60 days offense, my lord. Maybe,
So
my lord, he
during
got
vacation-
default bail, my lord. That is why.
May have been. What to do? Day after tomorrow or
Maybe day after tomorrow, my lord.
none appears on call. Keep full stop. It is submitted by the learned additional PP that information has been received that in the meantime, upon completion of investigation, charge sheet has been submitted in the case. Leaves the matter on 7-1.
May it please your lordship. Okay, my lord. Petitioner was arrested on, my lord, 14/11/2025, my lord, and as of date, my lord, 52 days in custody, my lord. Okay, my lord, FIR your lordship will find at page 8, my lord.
That has been received.
Yes. It is the FIR, my lord. Similar allegation against, my lord, Veer Lasit Chana, my lord. In recent time, my lord, many cases has been filed, my lord, by police against this, my lord, organization, my lord. And the petitioner also, my lord, while page 8 is the FIR, my lord. May I read the FIR, my lord?
Okay.
Page 8, my lord.
Page
8. Page 8. May I read, my lord?
Depends to the. Yes, go ahead.
Lordship. With reference to the subject cited above, I am to inform you that for the last few years in different area of the Golaghat district, the member and activist of Veer Lasit Chana, Assam, have been continuously harassing the local people as well as the non-Assamese business community on the ground of Asimyagiri and threatening them with grievous injury. It has been found in several occasions they have created unnecessary issue with local businessmen at Golaghat town for their personal gain without any valid reason and have humiliated and assaulted them publicly on the basis of caste, creed, and community. They have forced the non-Assamese business community to pay extortion money, and in cases where if anyone refused to pay, they were subject to violence and forcibly seek apology and videographed the same. The video of such incidents are then circulated in various social media platforms, causing great mental agony to the victim. The victims are so terrified that they refrain from lodging any FIR out of fear. Instead, for protection of their family member, they choose to pay the extortion money. It has also been found that Sri Avilas Bora, Secretary, Golaghat District, Sri Bitukon Sharma, Vice President, Golaghat District Committee, Raja Kolita, Raj Ahmed, along with the other member and activist of Veer Lasit Chana, obtained stop truck on highways during night hours and demanded money under the threat of assaulting them or handing over them and their vehicle to police. The drivers owners accordingly pay the demanded money out of fear. Over the last few years, the member of Veer Lasit Chana are promoting enmity between different group of communities on ground of language, caste, creed. They use derogatory remarks, slang language, and intentionally target the non-Assamese community as well as small trader for their personal gain with the above. With the active support from Rontu Panipakan Secretary Veer Lasit Chana, Assam, Vikas Borua, Vikas Assam, Chief of Kamruk Metro, and the other group leader of the Veer Lasit Chana. This FIR has been lodged by a police. Not only this, several many other FIRs also filed in different district. And the petitioner, while while in custody in connection with this case, he was shown arrested in another case, of Nagaon district, and in that case, he was granted bail, considering his share of detention of 21 days, and in this case, I am in custody for last 52 days, May I supply the other bail order,
52 days.
In this present case, 52 days, and in another case, in 21 days, considering the period of detention and nature of allegation, I was in bail.
anyways.
In fact, they have recorded a statement of the witnesses.
Mhm.
They have fully implicated the petitioners. These petitioners are the members of the Bill Lasit Senarachip, and they have engaged in widespread extortion and intimidation.
Mhm.
And they've also collected large amount of money from the various business holders.
Mhm.
And it also comes to light from my investigation, Lordship. They've frequently stopped commercial vehicles at night
Mhm.
and threatened drivers and demanded money. And refusing that, Lordship, they even if assaulted the drivers and threatening to kill them also.
Mhm.
And in one of the IONO Lordship, it is reflected that it is further noted that a prayer for the preservation and restriction on the deletion of incriminating videos and posts from the Facebook accounts of the accused persons has already been submitted to the Nodal Officer Golaghat. Accordingly, 6 videos have been identified showing the accused persons assaulting non-Assamese and Assamese businessmen across the districts.
Mhm.
So materials are there against the petition also. Several witnesses were examined. They have all the other business holders.
There are other cases also against him. One, he's got bail.
Yes.
This is another one.
Is another one.
Part I look of another part. Heard Bora. Yeah, Bora, na?
K. Buru Ahmed.
Lanit Council and D.C. Kosan. Invoking 483 BNSS, the two petitioners herein are seeking regular bail in connection with Golaghat PS case number 201 of 25. They were arrested in this case on 14/11/2025. And stated to have completed 52 days in arbitrary detention. What is the progress of investigation? To stop the case arose out of an FIR dated 28/10/2025 lodged by Inspector Mintu Handik of Golaghat PS with the allegation that the members and activists of one organization, namely Veer Lasit Sena, have been harassing people, including traders and business people, business persons, and extorting money from them with by causing threatening, threatening and instilling fear, and also videographing some of these activities and sharing on social media. It is alleged that some of these persons have also been demanding money from trucks on the highways at night. So the petitioners are stated to be office bearers of the said organization. The learned petitioner council submits, Mr. Bora submits that he was also prosecuted in another case in which being Colabor PS case number 115 of 25, in which by the order dated 18/12/2025, this court was pleased to grant bail in BA 4007 of 2025. The learned council draws attention to the length of detention and seeks bail at this stage. The case diary has been received. It is submitted by the learned additional DP Goswami that the investigation has lent support to the allegations in the FIR about involvement of the petitioners as part of that organization, of the named organization, in various illegal activities of extortion, etc., and threatening of business persons, including business persons from non-indigenous communities and stuff. What is the progress of investigation?
Some persons.
I will see it myself, but generally.
Obviously, here so there are several persons are against Lordship. Some persons yet
It
to
is
be arrested.
submitted that witnesses have been examined,
Yes,
several of whom have implicated
implicated.
the petitioners. You kindly give me the
It's
case.
like
diary.
matter.
I'll go to chamber.
Ulez.
Today only, I'll get the order.
Ulez.
This is
Case diary.
whatever, what is the matter?
Is there, then,
Diary has come.
may not receive, Lordship. Lordship, intimation was made from officer in charge of.
Nalbari.
33 days behind bar, Your Lordship. Your Lordship, may kindly come to the FIR. My ground is, basic ground is this, Your Lordship. That these are both, all the offences are, Your Lordship, under 7 years, Your Lordship. In view of that, Your Lordship, the provision of Your Lordship, BNSS, Your Lordship, section 35(3) ought to have been, Your Lordship.
Or
exercised.
justified.
That's
Why not
Lordship,
followed?
Lordship. That has not been done, Your Lordship. Straightway I have been arrested, Your Lordship. And Your Lordship knows about I have those.
Checklist is there.
Lordship. In their.
Nalbari PS. Can you get it day after tomorrow?
Yes, I can.
But I'll see. What
Lord.
else? I'll see.
Your
Day
Lordship,
after tomorrow.
kindly,
Where is Gorman? What is this notice is here? I'll have a look so that I'll remember then.
the grounds of arrest, etc. are not the grounds, Your Lordship. That has been furnished, Your Lordship.
That is okay.
Lordship. Only ground is, my ground is, Your Lordship, 35
yeah.
notice has
Why
not.
35 notice has not been given? That is
Not
not.
given. That has, Your Lordship may kindly go through the.
A prayer is made by the, intimation is made by the submitting our case there.
Whatever, he need not prepare anything. Whatever has been done till now, just send it. You can instruct us. Yeah, tell me which one.
Lordship.
Page.
That's page 18 is the FIR, Your Lordship.
Yes. That's okay.
Lordship, no, Your Lordship, here also on merit, one aspect is there, Your Lordship will kindly see that with due respect, we beg to inform you that we are the permanent resident of so-and-so. About 1-2 years back, we have got admitted in institute, namely Northeast Council of Allied Health Science Paramedical, situated at Santipur, Nalbari town, and doing our study there. We are now doing our courses, and some other students who have already completed their courses provided certificates to them by Gokul Sharma, one of the accused, Paresh Burman. I am here, Your Lord, Paresh Burman, the petitioner, and Osim Bhagavati. Some of our students have submitted said certificate while they applied for post of so-and-so
The
in
hospital
different.
said they're fake.
Fake. Now, Your Lordship will kindly see, I myself is in fact a victim. Your Lordship will kindly come to page 38. I have opened Your Lordship, center, Your Lordship, in the name and style of Chamata Paramedical, Your Lordship. And they, after taking money from this Gokul Sharma, give me affiliation, Your Lordship. For 1 year, that too, Your Lordship. When I came to know about this, Your Lordship, I have not pursued. Your Lordship will kindly come to page 38. This is to certify that Samata Paramedical has been provided status of Northeast Council of Allied Health Science Assam. And those who have submitted.
This has to be under registration. This is a medical council.
No, Your
Not
Lordship,
medical.
not. These are paramedical institutes, Your
But
Lordship.
there must be some authority, right?
Lordship,
Regulatory authority.
I took it, they say that they are
Hospital,
authorized.
opinion is not the final opinion. It has
Lordship,
to be cross-checked.
Page 37, Your Lordship, may kindly see. This authorization, after taking, Your Lordship, money from me, they have given to me. Based on this, Your Lordship, I conducted those, Your Lordship. For that too, for 1 year, Your Lordship. And those persons who have lost their affair, they do not belong to my institute, Your Lordship. They belong to the original institute at Nalbari, Your Lordship. Now, I have also lost the affair, Your Lordship. But the main culprits were not being arrested, Your Lordship.
But
I have been taken into custody, Your Lordship. And everything has been seized. Your Lordship will kindly come to page 28. All documents, etc. has been seized, Your Lordship. And
Bhagavati and Gokul Sharma are
they are
said to be main persons.
yes, Your Lordship. They are, Your Lordship, the
Or
owners of this.
instruction.
And in fact, Your Lordship will kindly come to page 26, Your Lordship. This, Your Lordship, will find that they have not disclosed why 35(3) has not been, Your Lordship, complied with. So far as I am concerned, Your Lordship.
Page?
Page 26, forwarding report, Your Lordship.
That's why we'll have to cross-check this from this thing also. Diary also. Anyway, get the diary day after tomorrow. That's all. Nobody please. Brief face.
Even otherwise also, your lordship, 33 days behind bar, all the documentary evidence,
So,
my
happening.
premises has been sealed.
People are desperate for jobs. and
Lordship.
These things are, happening, unfortunate. Anyway, let's see. The case diary is not yet received, full stop. The Mr. Bothapur Learned Council submits inter alia that one of the grounds taken in this bail petition is that though the offences are punishable up to 7 years, but there's no proper compliance with section 35(3) of BNS. So,
7-1.
7-1.
I have some judgments on that, your lordship. Shall I provide it, your lordship?
Day after tomorrow,
Lords,
or you can submit it. It will remain in the record
lords,
if you want.
lords. On next date, your lordship. Suppose that I go.
Yes. Yes,
We have not received the case diary, lordship. Here, this is in time or no?
This is that problem, no? Long time.
Long time.
Something is wrong in this. Otherwise, why will they not comply with order of any court?
It was from,
I think only
Not
charge
just,
may be
not just high
submitted.
court, huh?
Charge sheet may be submitted by the authority.
But
Then we
case
take-
diary, something should be there like the, আগৰ order to tata likhi dibo. Intimation has been received from the IO, seeking another date for the case diary. When he has sent, we should record, right?
yes.
But nothing,
We
what
have
is
com-
your instruction?
We have not even, we have not received any case diary. We have intimated on 19/12/25 also.
Yes. Peruse the last order dated 18/12/2025. Neither the case diary nor any intimation has been received. Though even copy has been sent,
Yes,
Hmm.
copy and message also sent.
though as submitted by the learned additional PP, both copy of the order as well as intimation has been sent. The prosecution said take instructions from the concerned police station.
Yes.
6171.
Well,
Very strange, because they send it. There's no reason why they won't send.
Okay.
After the
Day after tomorrow. Day after tomorrow.
45.
Case diary आना नहीं sir.
Your matter? Yes.
Lordship, case diary and FSL report has not
Achha.
yet arrived.
Not
Next
yet.
date maybe fix.
Another
Not received yet, lordship. The FSL report not received, that's why case diary is not produced yet.
case diary is received?
Not received.
Not
Not received. Case diary along with FSL report was called for, but the same is not yet received. Issue reminder, list on.
In time or something, in time, very in time.
Are you on? He's asking whether you're on interim. I think it's. No,
It's
it
not
should
in
be.
time, I think.
No, I don't think so interim. Once case diary had come,
Updated.
So for updation for the FSL what not, that's why the updation was called for. Lordship.
I think it is not there. Interim is not there.
So then lordship, immediately upon reopening of the vacation of
Just
20.
one order. You'll have seen one order. It is subsequent bill application.
Lordship.
This is a subsequent bill application. An earlier bill application, this is a subsequent petition. An earlier petition was rejected on 13/8/2025. First. Okay. So when should I fix it? No inter, he is not on it.
No interim. Lordship. So immediately reopening after vacation. Lordship.
Will it be okay?
Okay.
19th?
20 lordship. Okay, then lordship.
20? 20.
May it please your lordship. Lordship, pre-arrest bail application, lordship. Up to that CB was called for by.
CD was received once
Yeah, case diary received, my lord.
after, no, it was received on earlier date.
Case diary received. my lord.
But after making some observations,
Here in this case, my lord, after perusing the case diary lordship, interim was granted and
Yes,
directed
that's
to
what I'm,
appear before the
okay.
IO, my lord. Accordingly, we
They've
appeared
appeared.
and our statement has been recorded.
Mhm.
my lord.
No, their statement is
I
not in
had
the case
mentioned
diary.
that
my lord.
there is no endorsement regarding pregnancy. Toxicology report is negative.
Yes, my lord.
Medical document, one of the medical document annexed indicates that death might be due to chronic lung disease also.
Yes, my lord.
Right? That
Yes,
is
my
there.
lord. Now, my lord, whether, my lord, they have appeared or not, my lord, that is not, my lord, in the case diary, my lord.
According to your instruction, they have appeared.
Appeared, my lord, and
Record-
statement has been recorded.
recorded.
Yes.
My lord, that in the case diary, my lord, although, my lord, it was forwarded on 2011-2025, my lord.
Mhm.
But, my lord, the case diary, my lord, it is last update is as on 14-10-2025.
Long back.
Long time, my lord.
What should we do?
So, my lord, we can, my lord, call for the up-to-date case diary, my lord.
Keep it pending. It's long
My-
time actually,
My lord, yes.
long time. Yeah. Maybe.
But on interim, my lord, let it be after vacation, my lord.
The petitioners were granted interim bail on 25/11/2025 after perusal of the case diary. And after uh, making certain observations in para 5 of the said order dated 25/11/2025. First of, they submitted that pursuant thereof, the petitioners have appeared before the IO and their statements have been recorded. Though case diary has been received, but it is not, it is stated to be updated till only 14th of October. And the statements of the petitioners are also not available. Therefore, return the case diary and maybe procured again with updated investigation, including the petitioner's statements. Interim bail stands extended till the next date of hearing,
That will be on 29th-1, my lord, 29/1.
the 9/1.
Obliged, my lord.
May I proceed? Kindly pass over the minute of time.
After some-
Case diary received, my lord.
May I please? Sarsi have been submitted also, in the last occasion, scan copy of case there is
Yes,
Sarsi.
and it is available.
38.
Interim order, you're on interim.
Yes, Lordship. Furniture of FIR is at
Yes.
page 14.
I've
My
written
lord,
out.
in this,
That's
matter,
all robbery kind of.
yes, my lord, but Arms Act is also there,
Hmm.
my lord. So, my lord, otherwise, my lord, as per my lord, there is a cost list available, my lord. There's scan copy receipt, my lord. It shows, my lord.
Just a minute, huh? It is some, there's one more person. There was a submission from his side which has been recorded that
That
he
can
has
be
been
done,
falsely
my lord.
implicated
My lord,
because of working against some vested interest. That is
yes,
one of his submission. It has been recorded.
yes, yes.
So I have mentioned also considering normal circumstances, it may not be suitable. I've mentioned in the order, last order.
Yes.
But to various possibilities,
Yes.
he was given an opportunity to record his statement.
Yes.
Right. So in the meantime, we call for the case diary or scan copy.
My lord, in the, my lord, in the order, my lord, this TCR was called for, my lord, along with the CD and the CS.
I have mentioned case diary.
During
this order.
pendency of this case, Lordship, Sarsi have been submitted.
In the meantime.
That Lordship.
In the meantime, nice. Last order is for case diary only. Actually.
My lord, here, Dada, record to about looks ready to hasten.
I will just give you. As per the statements available here, they have admitted to committing dacoity. But anyway, the users see whether this will be enough or should we
Lordship,
call
all
for.
the four accused who committed a robbery, they were arrested
Hmm.
and they are bail in our lordship.
They've been granted bail.
Lordship.
And he's
You-
also state and is to
Lordship,
be involved.
somebody has stated that he is related.
He is also
in
involved.
lordship. But they have to prove lordship how is
That is
engaged
true.
lordship here.
Do you have copies of those orders given bail granted by learned court below?
Lordship rejected order is there, lordship.
No, that the bail of co-accused
No,
It was
lordship.
granted
No,
by-
lordship. They have perhaps lordship court below
court
lordship.
below. You
Right.
don't have the order.
No, lordship. They were arrested, lordship. They were on regular bail, lordship. My humble submission is that there must be some lordship evidence, lordship, that he is
Yes.
related to that.
True.
There may be lordship call records or so and so.
Some materials.
Even lordship,
Indicate his linkage also.
yes, lordship.
Otherwise, the allegations are serious.
My lord, here, my lord, that is a CD is available. The
Some parts
CD,
of CD
CD
is
is, some parts of CD along with that is your the search sheet that is available.
Charge sheet is available.
Search sheet is available.
What is the narration with regard to him? This person, Rajesh Hatimuria. Why he has, there has to be reason for charge shooting any person, right? Sometimes they don't write it so systematically, but still.
I have an order passed by this court lordship in a search sheeted case. Just to make clear.
It depends.
not
Facts-
going to the
facts
merit
and
of the case,
circumstances
sir.
of the case. Don't exhaustive.
My lord, in this case, my lord, in the
There
search sheet,
is allegation that the assailants, they injured his left eye also. Snatched away bail materials. Lot of atrocities in the family according to the allegations. Snatched away, beat them up, injured his left eye. Yes, these are true.
my lord, here, my lord, that is, his name is not stated in the search sheet as an accused, my lord. One that is Muhammad Hussein Ali is one accused, my lord. That is the one. Then Laturam Tati, another one.
Mhm.
Then, my lord, one Raju Tati, alias Daud. And my lord, one Profullanath, my lord.
But not him.
Now, this petitioner is, my lord, he is Ramesh Hatimuria, my lord.
Yeah.
And my lord, that is separate seat is there regarding the person who was not search seated. There, my lord, he is not search seated. My lord,
His
let
name is
my lord-
there in the list of not charged.
Yes, my lord, no, no, I'm just looking for that, my lord. That part is not, my lord, available, my lord. So, my lord, allowed some time, he is already in interim. Maybe it is a case where, my lord, after filing, in the meantime, when search sheet is filed, his name is not there as an accused. my
Probably
lord.
is not charged.
Yes, my
Maybe,
lord.
But
My lord,
maybe-
so then, my lord, there is no question of, my lord.
He's ready to face the trial. lordship.
No,
If
No, if
succeeded-
it is not
if
search seated, my lord.
Probably is not charged,
It
but
is
that part is not.
not search seated, my lord. My lord, then matter may kindly be fixed. He is already in interim, my lord. Not today, my lord. I will also in the meantime go through that, my lord, record. Or today itself also, my lord, after some time. Then I can find it out whether, my lord, he is search seated or not. Only that question is there.
After some.
Yes.
You don't know? That's okay. Join for it.
চাই দিম এইটো বেছি টাইম নালাগে ৰৈ দিয়ক।
And you won't need, these materials would be sufficient. this material
Ma-
should be sufficient.
If my lord, there, it is not succeeded, then
Yeah,
it is not a
if it-
case.
no, if it is not there in the list of
Yes,
persons.
yes, I didn't
And
get,
also see another thing, we'll
Yeah.
take it up after. some-
yes,
Second half after you
yes, yes.
have your lunch,
Yes,
after
yes.
lunch, we'll take it up. Another thing is that you also see I was just reading it, but I could not complete it.
Yes,
The statements of the co-accused,
yes,
though it is not so
yes, yes,
much admissible.
yes,
You just see where he
Yes,
was mentioning that like this, we went and we
Yes,
committed,
yes.
whether any name is reflected, probably
Yeah,
not.
yeah, yes,
That's
yes,
why he has not
yes.
charged.
That
After-
is,
after
that
lunch.
is required. Otherwise, my lord, here is a case where, my lord, there is the electronic evidences are there. The CCTV footages and all these things are there in this case.
He'll join to it. You are appearing, Mr. Majid.
Mine. Case
Also,
diary
the
is
informant is seeking VC.
Here, my lord, 69 of the BNS, my lord.
Acha. This diary was received once, no?
Diary received, my lord.
Sent it back again. And the interim order is there. Interim order is also there.
My lord.
It was directed to be sent back, my lord. Whether sent back or not, that I
Updation.
do not know.
Acha, acha.
Send back, update call করছিল আহা নাই রাতিপুৱা সোধা মতে
The CD is up to, my lord, 31/12, my lord.
Hmm?
31/12/2025.
Reasonably updated.
up to date, my lord.
Up to date is.
Well, we are-
Detail orders may written.
Here, my lord,
APS. Yeah. please.
yeah, with all respect, my lord.
Hmm.
Here, my lord, the petitioner before lordship is an SS officer.
Hmm.
His wife is also an SS officer,
Hmm.
my lord. And there is no denying the fact
Hmm.
that with the present lady, he had an extramarital relationship in between. That we have admitted, my lord.
Hmm.
We have not denied that, my lord. Have I made my position clear, my lord?
Yes.
And thereafter, my lord, with all respect, my lord, if your lordship comes to the affair that occurs at page 18. Page 18, first paragraph is good enough, my lord. Here, what 69 says, my lord, can I read the section of law first, my lord?
Yes.
It would be appropriate.
Deceitfully, no?
Even if I promise to marry a married man, my lord, if I have not deceived, my lord. Lady Maya is aware that I am married. After divorce, only remarriage can take place, my lord, with all respect, my lord.
67,
What 69 says, my lord?
69. Hmm.
Lordship may have found, my lord.
Yes.
And the Apex Court has also said in exactly similar context in a, my lord, same tenor, my lord. 69. Sexual intercourse by employing deceitful means. My lord, when this, my lord, BNS came into being, my lord,
This was a
the
nuisance.
parliamentary debate, my lord, it was to prevent primarily, my lord, love jihad, my lord. With all respect, my lord. That concept was there, my lord, and thereafter it came into being, my lord. Earlier it was not there, my lord. The 69, my lord, the head note is sexual intercourse by employing deceitful means, etc. My lord, the operative part of it, my lord. Whoever by deceitful means, by making promise to marry, this is very important, my lord, promise to marry to a woman without any intention of fulfilling the same, had sexual intercourse. Have I made my position clear, my lord? Here, my lord, I'll come to an authority man now, my lord. The man is married, my lord. Divorce has not taken place, and they are happily living as husband and wife even now, my lord. The petitioner before your lordship is living there by the accused and his wife, my lord. With all respect, my lord. Now, the affair reads as such, my lord. And the lady, my lord, she was aware that the petitioner before your lordship was a married man, my lord. Occurs at para 1, my lord. That from 14 September 24, long duration, my lord. See, Parthopotim Bormon, the petitioner before your lordship, was then serving as circle officer Dhubri, deliberately approached me, gained my confidence, and represented to me as was extremely unhappy in his marital life with so and so, accused number and accused number, she was also may have been made as an accused, was in the process of obtaining a divorce. On the basis of those solemn assurance, he persuaded me to believe that he intended to divorce his wife and marry me, and thereby giving me a lawful status in his life. Have I made my position clear, my lord? That marriage can take place because Hindu marriage is a sacrament, my lord. The lady belongs to Mohammedan faith, my lord. With all respect, my lord, it can take place only after when the marriage is divorced. Now, what the apex court has said in a similar situation, my lord, and Kerala High Court, my lord, here it is like this, my lord. Of course, in the apex court, where the subject matter of the case, there the lady was married, my lord. But the same principle would follow possibly, my lord. I am reading the operative part, my lord. This is as recent as 2025 because the section is inserted itself in 25. The matter went to apex court, my lord. Aman Bhagavan Nehul. There, my lord, would kindly have a look at para 8. Lordship may have found, my lord. There I'll be very cryptic, my lord. I'm coming to B. B, the later part of it, my lord, with all respect, my lord. So the same page. During this time, the Lordship may have found, my lord, the parties were already in a relationship. Here they are in a relationship, my lord. Relationship, and the alleged incident had already taken place. It is inconceivable that a complainant has engaged in a physical relationship with the appellant on the assurance of marriage, while she was already married. There, my lord, the lady was married. Have I made my position clear? Here the man is married, my lord. Same principle, my lord. Even otherwise, such promise to begin with was illegal and an unenforceable qua the appellant. This is most important. And that should be the principle of law, my lord. Because lady, I did not deceive her. I never told her that I was not married. Have I made my position clear?
But if a married person makes a promise,
Yes, my lord.
that he will marry,
Yes,
he will marry
yes, yes.
without saying that he is married or something, then the promise is obviously false because he cannot have a
No,
second.
no. Without saying he is married, it would be false, my lord.
False.
But if married, and then I say
That is then at the other person's risk.
exactly because she is aware of it that I was married. So, my lord, a married man
Then
cannot
it-
remarry
then-
another
then
Hindu
it
marriage.
may not be a false promise. Then it may not be a false
No,
promise.
it cannot possibly, my lord. It would not be a
It
false
would not
promise,
be.
my lord.
It
And that
probably-
is why apex court has said, my lord,
This is the situation. Otherwise, if he hides it,
it would
then
be, it would be an offense.
it may be.
No, it would be an offense of 69, my lord. Lordship is
Prima
correct.
facie.
Prima facie, my lord. My lord, this line is very important. This should be the ratio, my lord. Even otherwise, assuming I promised, and here there was promise to marry, despite he being married, even otherwise, such promise to begin with was illegal and unenforceable qua the appellant. Here, qua the first informant. Have I made my position? Exactly, my lord. Same tenor. Kerala High Court. Furthermore, Leukid, my lord. Can I just finish? My lord, I am reading it and placing it before your lordships, my lord. This is also 2025. Sayuz S. This is Kerala High Court, my lord. Para 8, my lord. Lordship. Listen, my lord. Lordship may have found para 8, my lord. It is before your lordships. Para is parting lines, my lord. Para 8, lordship may have found, my lord.
Yes.
If both the parties are aware about a subsistent marriage, it cannot be alleged that the sexual intercourse between them was with a promise to marry. Exactly, my lord. Had I not disclosed that I was married, then, my lord, the offense would have been complete.
Yes.
So, first of all,
Misrepresentation plus that.
prima facie expression, and my lord, the lady went to such extent, she publicized everything in newspaper, TV. Then I got a, my lord, with all respect, my lord, a restraining order, injunction, my lord, a restraining order that occurs at page 29, my lord. Property part I am reading, my lord. Did you have? Property part to Property part, my lord. Last page, my lord.
I think I've seen. There's a reference.
The opposite party, her man, my lord, the lady, my lord, she was restrained from, and our contention,
Temporary
my lord,
injunction.
and we stated that we are married. Everything, my lord, is
injunction.
there, my lord. And exactly when we got this restraining order,
Mhm.
my lord, would be exactly on the next day the FIR was filed.
Mm.
My lord, prima facie, ex facie, my lord, with all respect and folded hands, my lord, the section of law would not be applicable. And my lord, if I go to jail, assuming it is rejected, my lord, nobody would gain. During trial, if the offense is made out, and possibly offense would never be made out because I never hid from her while I made the promise to marry her that after divorce I'll be marrying her and I was a married man. Have I made my position clear? There is no deceiving or anything. My lord, 69 would not be complete, my lord. So far as the authorities are concerned.
His wife is also an accused, has been made an accused.
Oh, because we are together now, my lord. When the relationship came, my lord, out into the open, my lord,
Rightly given. And
I appeared, I gave my statement, my lord.
anyway, so
And wife lost an affair first in point of time, my lord. That also we have annexed, my lord.
Yes, my lord, we have received the case diary, my lord. Investigation has sufficiently progressed, my lord. The victim statement has been recorded, my lord. Medical report has been collected, my lord. And my accused person, his statement also recorded, my lord. Now, my lord, in her 183 statement, my lord.
He's let him be furthermore specific, my lord, whether my bail prayer should be rejected and I should be in jail, my lord, SS officer. And my initial, well, I'll only, my lord, face the consequences during trial, my lord.
there'll be time.
Yeah, lordship.
May I assist your lordship? I am
For
appearing
informant,
online on behalf of the respondent.
Yes.
I apologize, your lordship. Because of my illness, I can't appear before your lordship physically, and so I had to use this medium.
Mm.
Your lordship may kindly come to my affidavit in opposition. As for my understanding, your lordship, it has been impressed before this honorable court
Increase the
that
volume, just to.
that my FIR was lodged after filing the title suit.
Hmm.
But my lords, that is contrary, untrue. I have been, if your lordship may kindly come to my affidavit in opposition, annexure 2, I lodged a complaint before the National Commission for Women way back in 10/9/2025. And I was of the understanding that this, my complaint at the NCW has been followed up by the Dhubri police.
Okay.
My lords. So I just want to get the facts in order, my lords. Second, your lordship, they have accepted it. They have accepted it that they were in relationship with me. In their title suit in annexure 1, they have accepted it that they were having a relationship with me. Now, your lordship, the only question will come whether at the initiation of that relationship, whether there was they had this the intention to cheat me. If that is the case, then 69 will attract. Now, what they have done is, my lords, your lordship will see it's the accused petitioner who approached me. I was a consultant. I was a training teacher at a school, my lords, and I came across him in an official program. Subsequent to that, he approached me in a social media account. My lords, I made myself very clear that I am not going to get into any relationship. Then subsequently, he promised me that, see, I am going to get divorced, and that has also been it's there. Now, my lords, I have annexed a WhatsApp chat at page 78 and to 86, in which, my lords, it's a personal chat in which he categorically accepts that that he is going to divorce the petitioner. Now, your lordship, in this 7 to 8 months in the relationship which I had with the accused petitioner, your lordship, there's a history of torture, there's a history of abuse. All of this has happened, and it has all been supported by documents. There is also a medical document at page 87 to 91, which I have annexed, my lords, which says that the kind of torture and the autonomy that I lost while being in a relationship with him, my lords. Now, my lords, B, what he is doing is this. What he has done is that, my lords, he has initiated two cases against me. One is the title suit, which is done only to intimidate so that no one comes forward to file a case against, come and gives a witness or files a case against the accused petitioner. So will kindly please take a note, because already he holds a very influential position. He is an ACS officer of this district. Second, your lordship, even after getting this interim, he has gone and filed a criminal defamation case in a Nalbari court, my lords. No, and now I am a woman. How am I going to go and respond in this frivolous petition that he is going and again filing in different courts across Assam? My lords? And all of this is done only to intimidate me, my lords. So may kindly take a note of this, my lords, that which throws a very bad light on the ways of the accused petitioner, my lords. So that will be my humble submission, my lords.
May I just add a line, my lord? One thing is incorrect, my lord. Whatever I have said is absolutely correct, my lord. The injunction order is dated, with all respect, my lord, 6/11/25, and that is apparent on reading, my lord. With all respect, my lord, page.
From Civil Judge Junior Division, Dhubri.
29, page 29, my lord.
Yes,
Page
I've actually-
29,
actually-
injunction order is at
Actually.
6/11. We may have filed it earlier, that's besides the
Civil
point.
Judge, Civil Judge.
6/11.
Uh-huh.
And the FIR is dated, my lord, 7/11.
Mhm.
That occurs at page 18. Let me make matters straight. And he read out the statement, the learned public prosecutor, who is vehemently, definitely, my lord, he has to do his duty, rightly or wrongly, to support the prosecution. Well, that's his plus point, and everywhere he does that. He's, my lord, very good. But he stated that a lady came for a job and thereafter got introduced or by in Instagram. I never approached her. That's wrong. And this FIR is dated page 18, my lord. 7/11, my lord. Page 18, apparent, my lord. One day hereafter, counterblast is this FIR after the injunction order.
I'll go through, I'll take some time to pass it.
This is our case, my lord. And my lord, let him face that. And if he goes inside, it's not, Indian criminal justice delivery system is not punishment before trial, my lord. With all respect, my lord. Everyone knows it, my lord. I am not to repeat it, my lord. With all respect and tolerance, my lord.
Your lordship, but if your lordship may, but he will see also take note of the way he has been filing multiple litigation.
Is there
across
any
the
bar?
state of Assam, my lords.
There's no bar, but it should not be malicious. The only thing is that. Is,
My lord, I am taking legal recourse because a lot of things have been said against me and my wife.
True.
Either way,
Is he from Nalbari?
my lord.
Is he from Nalbari? He's from Nalbari.
Yes, he's from Nalbari.
That's
my
why he has filed in
lord.
Nalbari.
Yes. Nalbari. Yes, my lord, I have been told that he's from Nalbari, my lord.
Anyway, your affidavit is, you filed an affidavit, right? You referred to.
Yes, your lordship.
I'm not getting the affidavit because I need it to pass the order. Nice one. No, it's not the one. When did you file it? Sometime back?
Part of the record.
It will be
10/12, Your Honor. On 10th of December, affidavit was filed. On 10th of December.
Achha, you are appearing for
the same.
for the information. Any submission from your side?
Your Lordship, paragraph number
10th of
12,
December,
paragraph number 12 of the
should be
affidavit.
there.
It will be.
Primarily, it's a relationship dispute, but it got very messy. So anyway,
Abuse of power,
they
basically.
should, that I don't know, that, but the thing is that,
Our paragraph number 12 of the affidavit may be taken into consideration. That the FIR was not launched after the title suit, but initiating of the proceedings against the person started before the National Commission of Women on 10th of September 2025. And when we were waiting for the Dhubri police, based on the intimation of the National Commission of Women to investigate, therefore the FIR was launched. In the meantime, the title suit came into play, Your Lordship.
Diary has not been received, scan copy has been received.
No, diary has come, my lord.
Scan diary.
No, no, my lord, original diary, my lord.
Original diary. This is not the original diary. This is the original diary.
No, this is not the diary, my lord, I made this.
Yeah, diary. Well, right.
Diary others.
So anyway, so
Well, can I just add another
Yeah,
line, if you
please.
permits me, my lord?
that's why I'll take some
My lord,
time.
the first chronological thing is,
Carefully, I'll see.
first chronological thing is, my lord, the injunction order is dated 6/11,
Right.
2025,
And the
which
FIR
is annexed, and the any, my lord, with all respect, any spectrum, my lord, absolutely, my lord, regarding section 69, and assuming, my lord, offense is complete. Even in that event, after, my lord, being a government employee, no flight risk, he appeared, gave his statement. Have I made my position clear, my lord? Let him face the consequences during trial. He appeared on 3 days, my lord.
Just one thing.
No, why should he appear 3 days? He has
No, no,
got-
I appeared
Just
3 days, my
one
lord.
thing,
Police called
just
me. my
one
lord.
thing on facts. Just to
15
add one thing on facts.
Let me complete, my lord, thereafter, not before. 15, 16, my lord, these are my factual statements. We appeared on 15, 16, and 19th, my lord.
What is his present position?
He is, he koriye
It's under secretary.
he is Under Secretary Revenue, my lord. With all respect, my lord.
Anyway. So. I'll see it.
My lord, my lord.
Anything, you wanted to say something?
Just two things, Melits. May I just bring up?
Yeah, quickly. Yeah, go ahead. Go ahead, go ahead.
Yes, Your Lordship. So the injunction order that was served to me only on 10/11/2025. I came to know about the injunction order only on 10/11/2025. And
That is
the
another
order, my senior counsel is absolutely right that the order was passed on 6/11/2025. But the copy was served to me only on 10/11/2025. So that's one part of it, my lords. And the FIR I lodged on 7/11/2025. That was a formal FIR. But before that, even in 6/9/2025, I made a complaint before the National Commission of Women. In my affidavit in opposition, it's there in Annexure 2, my lords, in which I was of the understanding that and complaint before the NCW is being taken cognizance by the Dhubri police, because the procedure was that the National Commission for Women actually transfer the complaints before the jurisdiction police station. So that was my understanding. And subsequently, even I visited the police station. All of this I have mentioned before. Yes. And my lords, my second thing is this: I have also recorded my 164 statement before the learned magistrate.
That is there. You submit the case there. But
Yeah,
what
so
about
the Lordship
the
may
affidavit
kindly
is not here? No? Where-
peruse that, my lords. And thirdly, my lords,
No, it should be in the record. We have to get it in the record.
Filed on 10th of
That's-
December.
It should be in there because of the holiday.
One line I am on in, my lord, whatever be the date of receiving these are not material. Material would be applicability of law, and whether my lord, with all respect, my lord, custodial interrogation is necessary. Here no recoveries are to be made,
and
that I have
thirdly-
fired a gunshot and the gun is to be recovered. It is not a
Yes,
case
and
like that, my lord.
yeah,
With all respect
thirdly-
and full reverence.
Thirdly, my last submission, Your Lordship, is that, my lords, the series of incident that has happened has all lost my autonomy. I have lost my autonomy. I had also attempted suicide, my lords. So all of these, my lords, there has to be some remedy, some recourse that this law has to provide for me, my lords. So that will be my humble submission. I leave before Your Lordship for consideration. Much obliged, Your Lordship.
Obliged, my lord.
I'll pass it today.
My lord, in respect to item number 37, my lord, may I pray that, my lord, matter will be taken up tomorrow, my lord. I have got some difficulty today after second of, my lord.
Is it?
Item number
37 we have
37
kept-
tomorrow, my lord.
Okay, 37 tomorrow.
Tomorrow, my lord.
Tomorrow. We had received this thing?
Receive the case diary, my lord. Yes.
Okay.
Yes.
Okay. Okay.
We'll retain it for tomorrow, my lord.
Okay, no problem. Also, that Hatim Muria,
My lord, yes.
that matter, no? That
Yeah, but
robbery.
That I have gone through.
Also, that 37, sorry.
37 is, my lord, is pass over for the time being, my lord.
Oh,
May I pray, my lord, tomorrow, my lord.
tomorrow.
My lord.
My lord, last hearing date was given 18/12/2025.
Your fault, which
I
I,
appeared before the BC link. And on that day, my lord left the court 5:17 PM. I have heard all these things by computer as well as my mobile. Sudden status position, it was not shown in the status position. The date was hearing was today.
I see.
Fortunately, I came here to know about the case,
I see.
and Honorable Master of the Court told me that today is
Your
the date of hearing.
item
19.
number?
It is a very said. It is very much unfortunate.
Not listed today? It is listed today. 9.
And this court master told that my case was admitted over telephone. Repeatedly I sent a message to him.
It's at,
Kindly
it's at the stage of motion. It is anyway.
kindly rehear the matter.
It is no. It has not been heard. It is last time today. It has come up for the second time, but it has not been heard. I'll hear you today. Can you
Status of the case is it is to be given.
Okay.
Today is the date of hearing.
Okay. I'll tell the registrar. I'll tell him. I'll tell him the update is. Okay. Will you do it today? Will you argue today or another day?
Pardon me?
Would you like to argue today?
Yes.
You want to argue today?
Yes.
Okay. Go ahead. It's all over. ঠিক আছে. Okay. Mr. Doctor.
My lord, I am the informant of FIR for wrongful arrest in 407 minute containing CCM. Actually, fact is this: my witness has submitted a petition dated 15/9/2025 that his statement of evidence is to be taken down by Bengali language, as he does not know the English language. Page number 18, my lord, and this is the page number 18.
Government advocate is appearing. No name is shown.
Page number 18, my lord.
Nothing is no.
My lord, here it is a petitioner in person, my lord. The party is one Madhumita Sharma. Government is not the party to this.
Once. Anyway.
Because it was the offense committed by the irregularity committed by the Honorable CGM of Silchar Court.
Anyway,
so I cannot make any party to anybody.
Okay. Let us see. Let us go into it.
And it is legal rights. Under provision section 277 CRPC, that witness statement is to be taken down by his own language clearly. And Naim Ahmed versus State of New Delhi case law I have also given.
Okay, I'll see.
It is permissible. But his statement was taken down in English language. Also, I raised the objection, but it did not carry out it.
Just a minute.
And at last he was compelled to put the signature. Then he submitted a petition that his statement is to be taken down by memorandum of objection under provision section 278. Page number. Page 36 to 30.
So, Doctor, what is your prayer here? You are seeking withdrawal.
We can speak to correct the deposition case 46 to 55, my lord. It is also permissible. Even then, I being the petitioner, I also submitted this statement is to be taken the correct evidence under provision section 311. Because he has this witness has already submitted the deposition statements in the complaint case, complaint case number 167/2020. I have enacted all these things. Correct deposition 16 to 17. And the Honorable Judge, Honorable CGM, wrongful statement of version of CGM tried to take the vehicle to whom was the complainant, found the broken culvert. Culvert was broken 2018 in the month of June. Page number 36. 36 to 37. No, sir. No, my lord. 15A.
Uh,
15. Joint complaint was given to Silchar Municipality Board by docket number 187 dated 10 July 2018 for restoration of 1 feet slab of the culvert. Till then, pending all these things, my lord, I don't like to appear before the court again with such abusive process of court. I pray for withdrawal of my FIR. It may kindly be under the inherent power of the Honorable Court under section 482.
Withdrawal of the
So,
You want to withdraw the FIR?
my lord.
No, you want to withdraw the FIR?
Yes, my lord. He is also undertaken in step. I
have not fully
requested,
understood,
although
actually.
I have committed mistake, there is 57 actually to
Okay.
C21, public prosecutor. Public prosecutor wants money, one more for money, date of hearing, one after another. I don't like to appear before the court, although I've got the license as an advocate, but I don't like to appear before the court. It is because whenever you hear any false statement before the council or there is contradictory evidence, I become puzzled. I don't like it.
Just a minute.
So kindly allow me not to appear before the court and withdraw of my FIR. Actually, after committing the offense that Madhumendra Sharma filed the FIR against me, and it was discharged by the Honorable CGM Sri A. Gogoi. Very much honest after hearing all these things. And thereafter, communication petition was filed in Silchar court without notice, without a date of hearing. And again the Honorable CGM, another CGM framed the charges. I committed mischief for bringing the truck. I am not the driver of the truck. Section 211(5), subsection 5, balloted. The fact that charges made equivalent statement. Every legal condition, every legal required law to constitute the offense. I am not the driver of the. How I can bring the truck? False framing of charge cannot be done.
Where is the?
Ultimately, you move to the. This was this case was dismissed by this is Honorable some Manashri Honorable Justice Manashri there. Then I appeared before the Legal Service Committee, and Legal Service Committee admitted the matter. And after all, I went there 12 times in Supreme Court, and after leave was granted. All these things are. How much crime is there, offense is there in the Silchar court?
Have to go to. Since you have made this informant Madhumita Sharma a party, we have to issue a notice to her, right? We have to. You stay in Silchar, sir? Do you stay in Silchar?
I couldn't understand.
No, do you stay in Silchar town?
No, yes, I am. I shall go as early as possible.
No, you stay.
Yes,
You stay in
Silchar.
Silchar.
I'm staying.
You need not come all the way in this weather. Next time you appear through video conferencing.
BC link.
Through BC. Need not come.
Again, kindly next date of appearance is 17 January 2026. So I don't like to appear before the court because it is very much disastrous for me. So kindly
This is actually
grant my appeal.
Actually, this is a criminal petition. The content is like a criminal case. 482 jurisdiction. It's actually 482 jurisdiction, but I am not fully understood actually what is. He was the respondent is the informant. There was one case actually.
Respondent is the informant.
No, I am the informant. Respondent is not the informant.
Okay, you are the informant.
I am the informant. I am the informant.
She is the accused.
Misleading it.
No. I'm saying this. PRC, you are the informant in.
Yes,
which
yes, yes, yes.
Led to the
Yes,
registration
667,
of
I am the informant.
Where is the complaint? You filed the FIR.
Yes, I filed the FIR.
Wait, can you show me the FIR? Where is the FIR?
Yes.
I'll also. PRC 687. Let us target
Yes.
that. PRC 687 is the case where he is informant. And there was a prayer for recalling of one witness.
Witness. His contention is that what I
it was
understand is that it
rejected.
is not in the, his,
No, that prayer that was rejected.
that was rejected.
He has come against that. But we'll have to issue a notice, right, to the
Yes.
person.
Yes, my lord, he has certified copy, my lord, that is regarding that, the FIR.
Yes, yes.
Yes, that is. And in that case, my lord, if it is a PRC case, my lord, then state be a party. So, my lord may reflect in the order, then PP's name should be shown, so
Yes.
that we
State
can
can be a
assist
party.
this honorable court.
State can be a
Other,
party.
not exactly PP, my lord, because my lord, it is filed as a WPC criminal,
WPC.
government advocate, government advocate.
Government advocate. Actually, it is the jurisdiction is.
Actually, my lord,
For a-
criminal petition, it should be criminal petition. Otherwise.
My lord, it
Deva
is a
Prasad.
conflicting matter. It is conflicting, it's a public prosecutor. Can the public prosecutor go against the honorable CGM? It is a conflicting. It is not a clear facts and circumstances of the case. And it will take time. So only my honest appeal to withdraw for withdrawal of my FIR.
He wants to withdraw his FIR. He says. But,
Well, it's a
for-
And even either my lord, if the water is passed before the superintendent of police, the water is passed that under provision section 173.
No, you can submit an application before the IO if you want. If I have understood you correctly, sir, that you want to. If I have understood you correctly, sir, that if you want to withdraw your FIR, then
Yes.
I don't have to pass any order. You can just file an
I-
application before the IO.
I have
He will
paid-
do.
I
He
have
complete
paid-
the
I-
investigation and file an FIR. Yes.
I have paid in my petition, my lord.
But because the FIR cannot be.
Can you give me relief, my lord, and save the justice?
Otherwise,
That petitioner further paid that he may kindly be allowed for withdrawal of FIR bearing PRC number 687, and again the FIR number 2976, dated 1st October 2020 of the information and offense under section 341 wrongful restraint and 294
okay.
misbehavior and 5060 million intimation and 34 IPC. All these offenses are compoundable offense, my lord.
You want to withdraw?
Yes, compoundable offense can be considered by
Court.
ST also. If the order is passed, SP can also do it. This is only process. I have also moved because I don't like to appear before the court at all. It is,
I'll dispose it off with a direction that you'll.
yes,
that
close.
you'll give an application for closure.
Yes, my lord.
Just yeah,
But what I understood is that, my
Ah.
lord, this trial has already been commenced.
guide me. Yes.
State of the case is essential. What is the state of
All
the
the
case?
is comment, but till then, even the charge sheet is formed. After the charge sheet, it can be converted. If the SP is given the instruction to investigate further investigation, and now from that day, 5/3/2019 till today, she did not sustain and did not misbehave with me and did not give me criminal intimidation. So on basis of facts and circumstances of the case, to make, for maintenance of tranquility with her, kindly allow this withdrawal or that.
Yes, my lord.
And I have already prayed in my application
doesn't want to
petition of
pursue
the
that.
public to,
If I've
that
understood correctly.
Mohammed Sharma is no longer used to restrain the vehicle as well as to petitioner over the public road, misbehave with the petitioner and threaten to convict the case is 12th, my lord. That is in my, that is very much hard for petitioner to appear before the criminal court
It's
for
okay, you know,
prosecuting
do some
and
reconciliation.
suffer from hypertension after being attained the age of 71 years old patient. And it is adversely affected for freedom of movement granted under Article 19(1)(d) of the
My lord,
Constitution of
what I
India.
understood is that,
What
my lord.
happened was that there was an allegation that she tried to restrain some movement of.
Yes, yes.
With regard to that.
Now.
It was filed
no-
and during the proceeding, one statement was recorded.
Yes,
He-
ma'am.
Mr. Dotto had a grievance that it was, it should have been recorded in the language in which it was spoken. that is
Yes.
Bengali, but it was
It-
recorded in English. that
It is the alternative prayer. It is
and
my alternative
Despite
prayer.
that, it was recorded and he
It is my
constitution pending before the learned CGM Kasar at Silchar. Full stop. The said PRC case was registered, PRC case within bracket, GR number 4741 of 2002 was registered based on FIR dated 1/10/2020 lodged by the petitioner hearing. Against the respondent Madhumita Sharma, unnamed others. Can you help me, Mr. Boyso? Can you help me with the, what are the sections? Yeah, it was registered.
No, my lord, that I am looking, my lord. What are the exactly sections?
341, 294, 506, 34. Penal provisions. given.
What not issued, the alternative prayer.
506.
That will make an issue.
The case is stated to be at the stage of trial. Oh, the case is stated to be as
It
stage
is the
of
trial stage.
trial.
Trial is going on, no?
Examination of witness.
Yes, evidence is being,
Understood.
evidence. As I
Yeah, at the stage of evidence. Mr. Doctor, the learned petitioner in person submits that
I was ready to.
he does not, that all the provisions, penal provisions, which are subject matter of the PRC proceedings are bailable in nature, and that he also does not wish to pursue this matter, and that he may be permitted to withdraw the FIR. So I dispose it of with the observation that
Yes, yes.
copy of this order will be sent to the court below.
Yes, yes, ma'am.
Stop. In the, I've also heard a full stop. Should I record your, not record,
My lord.
what capacity?
Oh, my lord, only because, my lord, we are not made, otherwise it is a
Informally.
PRC case, and here the thing is that in the petition, my lord, one thing I have observed, my lord, there is though 226 and 227 article. There, my lord, they wrote, my lord, there is 482
Yes, I've
CRPC.
seen also.
If 482 is there, we can be a part. We can be a part, but not in the
Yes,
WPC criminal.
Yes, inherent power
Has assisted,
to secure the end of justice.
assisted the court. As the petitioner is appearing in person.
Can you help me?
In the facts and circumstances, the petitioner is agreeable to disposing of the present writ petition with observations in the context of his submissions recorded above. Therefore, this writ petition is disposed of with the observation that the petitioner would be at liberty to seek compounding of the offences. Would be at liberty to submit a petition. Would be at liberty to pray before the court, orally or through a written petition for compounding of the offences. For this purpose, a copy of this order shall be sent to the learned trial court, that is court of the learned CJM. What I have done, I have incorporated you to your prayer that you don't want to pursue this case, and I've disposed of the writ petition. A copy of this order that I have observed that the offences are bailable, compoundable, they are compoundable.
Yes, yes, yes.
And a copy of this order will be sent to the trial court.
Yes, yes, ma'am.
Just take one trouble kindly, since you are staying in Silchar, just go to the court once and give them a.
And SP also.
You go to the court. The court will receive the copy after say 15 days or something. You go to the court and or as per your convenience, but don't make it very late. Go to the court and show a copy of this order. A copy of this order shall be given free of cost to the petitioner.
My lord, only there, I think only 3 sections are there, my lord. That is
Yes.
one is, my lord, that is 341. My lord, that is 341 is also compoundable.
Compoundable. 294.
And one, my lord, 294 or my lord 298 exactly.
It's also compatible. I have seen.
290.
Yes,
Yes.
it is also compatible.
And my lord, that is another one is, my lord, that is the 506.
That is compoundable. That is
Five-
compoundable.
Yes, my lord, 506. But my lord, that is 294, my lord.
294 is
294.
not compoundable.
It is
Yes.
a pity matter, misbehavior,
yes,
my
yes.
lord. You have seen, yes.
Now, we should all have a sense of reconciliation.
Yes, yes.
In especially if it is not serious.
It's minor,
Yes.
minor.
Yes.
I appreciate your efforts anyway. What has happened?
I should be very much grateful.
No. I have not done anything for you. It's a small thing. You have come all the way from Silchar. You could have appeared through this thing, video conferencing. So,
Yes.
it is. This order will be given to you free of cost. This order.
Actually,
And
on that
And
day,
I will send a copy of this order to the concerned court. So you just go one day
Yes.
and submit this, and the rest the court will do.
yes,
They will do.
Right.
Okay. Because since the other party is not here,
Yes, my lord.
so and without knowing the
Yes,
details, it will not be proper for me to pass compounding
My lord.
because it will be risky.
My-
Best is the trial court will pass.
Yes, my lord.
it's not related to respondent, my lord. Actually, it was done, by offense is committed by Honorable CGM. Because there is something is there, I don't try to express before the court.
No, it's okay.
But whatever it is very much unfortunate.
It's a compound.
It's very much
Don't
unfortunate.
use such word.
Anything else? You're going back today to Silchar? Today you're going back? You'll be going back today?
আপনি কি আজকে গেছেন নাকি শিলচর?
Yes, I should go back.
Copy এটা দিবি, হ্যাঁ? বেশি time না লিখে দেবো এটা। Copy দিতে।
Actually, I'm short hearing.
Okay, okay.
Doesn't matter, so.
41.
Yes, there is something received. Can be
Yes, I not received yet.
you vacation my
Updated, I think once it was received. Right? One.
41.
Which is the Thana?
Himanshi.
Lotasil.
Lotus Silva.
Another day. Case diary is not yet received. Issue reminder. List on.
21-1.
It's okay for you. No problem. Okay.
Obvious, Prof.
Timing item 2.
It is in this case, charge sheet submitted lordship.
So during
Malab, made preserved. It's second application, Malab. Earlier it was rejected by Lordship. Now, Malab, since charge sheet has been submitted, Lordship may kindly call for the scanned copy of the Malab because it was earlier rejected by Lordship, Malab. Because during the pendency of this application, possibly the charge sheet has been filed. Because it's a case of somebody has been killed, so I'm not pressing as of now.
No, that's what I was saying. Otherwise,
Yes, ma'am.
sometimes we can dispose it also.
Lord,
You call for the scan copy. Yes. Well, anyway. The learned Mr. Chaudhary, A. Chaudhary, heard A. Chaudhary and D.P. Goswami. Chaudhary Learned Council clearly submits that an earlier bail petition was rejected on 18/12/2025, passed in BA 3549 of 2025. It is informed by the learned prosecution that in the meantime, the case has been charged sheet. Charge sheet. Full stop.
Part CS number 126 of
Right, CS number
126 of the 25, dated 6/12/25.
6/12/2020. Mr. Chaudhary Learned Council fairly submits that perhaps the scan copy may be looked at. Call for the scan copy of scan TCR.
Scan TCR.
Comprising case diary and charge and other relevant materials. From the concerned learned court, which is court of
Bongaigaon.
Bongaigaon. Jogi Gopal de Bongaigaon. Concerned learned
Because Sessions Tribunal,
may not have been committed also. They
that is true now.
may not be committed also
Yes.
by the time. Concerned learned court.
Concerned
Yes,
learned.
that is-
In the district of Bongaigaon.
After vacation?
After the list on this 2020
Lordship.
20th January.
Much obligement.
I know.
Timing item 3.
He lordship, there is a notification by the Honorable High Court lordship. That is the Honorable notification number dated 14 November 25. This Honorable Guwahati High Court is pleased to notify the following up for dealing with cases which do not involve foreigners tribunal but relates to issue of citizenship, NRC pushback, deportation and other ancillary matters thereof. Such cases shall be categorized under a new category code 10310. Citizenship, NRC pushback, deportation and other ancillary matters. This category of cases shall be listed before a division bench taking up foreigners tribunal matters. He is the standing counsel for foreigners.
Oh, yeah. It's fine.
Generally, there are two categories of cases if a foreigner is found in India. One is directly related to Passport Entry Act, that is a penal provision on date. And another is determination of foreigners, whether
Yes,
he is a
ma'am.
foreigner or not. That will under Foreigners Act 1946. And there the burden is on the proceeding to prove that he is a citizen of India.
Yes.
In that case, tribunal got the jurisdiction, the foreigners tribunal. In other case, in normal case registered under the Passport Entry Act, those are penal provision, those will be dealt with by a normal criminal court. So now as I have got information, in normal case, he has been granted bail.
Yes,
Yes.
it's been
That if-
because of some violations of those acts.
Yes,
You know,
that is-
passport,
in
etc.
that
He has
case,
been, a
yes.
criminal case has been registered, he has been released
Yes,
on bail.
Release on bail.
Granted bail.
Yes,
Not
now it is the foreigner, it is sent to the foreigners tribunal for determination, whether he is a foreigner or not.
Yes, yes.
In that case, if any order is passed by the foreigners tribunal, that's what my understanding as per this notification and the procedure, if any order is passed, there is no appellate provision in the foreigners act and foreigners tribunal order. So they will have to come by way of writ petition in the Honorable High Court under 226 certiorari jurisdiction, supervisory jurisdiction. So in that case, those matters has to be placed before the division bench. That is the normal procedure. That's why, probably if any order is passed by the foreigners tribunal, but then they'll have to go to the writ
Yeah,
jurisdiction.
they tried for bail before the tribunal.
Yes,
The
yes.
tribunal was pleased.
There
to
is
reject.
provision of
They
bail, my lord.
have come. So the
Yes.
thing is that it will be it has to be taken up by our
Yes, my lord.
FTD.
Division bench, but it has to come by way of writ petition probably. Because there is no, my lord, the foreigner sex says, my lord.
Oh, what's up? It's a BA, right?
Yes,
Oh, yeah.
that's not a
I
normal
have not seen
CRPC.
BA before.
Yes, yes, yes.
Probably.
Yes.
That's a technical
That,
part that can be taken care of.
Yes.
That can be taken care of.
Yes.
That can be slight modification and then you can find.
Yes.
Okay, let this, as I told you, no,
Yes.
there is no, you
Yes.
have a remedy,
Yes.
but
Yes.
you have to see what will be the correct
Yes,
path.
Yes.
Right.
That is the procedure.
Mr. Payang.
Yes.
Your good name, please.
Yes, J. Payang, my lord.
Jay Payang.
Standing counsel for the foreigners and FT matters.
I approach this court, my lord, as because I have already been granted bail.
Yes, yes.
The bail by the Honorable Madras High Court. And my bail petition has been rejected by the Foreign Tribunal. So I prefer this bail application, my lord.
No, it's okay. That is how we learn. Heard to Jay Payang, the standing counsel for the
FT and border matters, my lord, Home Department.
It appears that I won't say much. No, but,
Yes, my lord.
it appears that this matter has to be placed before the division bench dealing with matters pertaining to foreigners tribunal. Should I record that observation? That
not
submission of
necessary.
yours, that it may be perhaps through.
No, my
WPC.
name may not be recorded, my lord. It is because I am not a party.
So that's okay, no problem. So accordingly, this matter will be placed before the division bench, appropriate division bench, as mentioned above. So, but if it is placed in this form as a BA, then
My lord,
again,
my lord, my
it will waste
submission
some
is
time.
that
That's
it
why-
may be placed in the manner of, my lord, writ petition.
Yeah, that's what.
My lord, may I suggest, my lord? Let this case be pending, my lord. Let this matter come up after 2 weeks, my lord. If I am not get the relief in the division bench, my lord, I will do this case, my lord. That may also be done, my lord.
It will waste your time. actually.
That cannot be done. That could
It
be
will waste
without
your time.
interest.
My lord.
So it may waste your time. So it's better, that it goes.
Right.
But the petitioner is at
I may be given the liberty to withdraw, my lord.
withdraw.
Yeah.
At this stage, the learned petitioner counsel, that is all.
Liberty may be given.
Submits that perhaps he may also be given the liberty to withdraw this bail application and file it afresh for the
Before the appropriate bench.
appropriate bench by way of a writ petition. That will be right. Then we best. Thank you. Disposed of accordingly.
2014.
Please, your lordship. FIR is page number 16 onwards. Relevant page is page number 19. Your lordship. FIR is registered
AB,
under- AB, your lordship, registered under section 316 and 318 oblique 61 of BNSS. lordship. Relevant page is page number 19. Your lordship. 19.
Yeah.
Caused by Chief Executive Officer of Assam Cricket Association.
Cricket matter, no?
Yes, lordship. Allegation is based on mere suspicion, your lordship, there is corrupt practice and match fixing, your lordship. Annexure A, page number 21, your lordship, this is the inquiry report.
21.
21. Background of the inquiry: suspicion on field performance, direct corrupt approach, and conflict between players, your lordship. Now, page number 22,
Who are
Your
the present petitioners? Their name is
Ihsan Ahmed, Lordship.
one person only.
Yes, Lordship. Ihsan Ahmed, Lordship.
Okay.
I have been implicated in this case, Your Lordship, because page number 22.
Your name figures in the inquiry at?
Yes, yes, Lordship.
At?
Lordship, page number 27, last para, Your Lordship. Page number 27, last para, Your Lordship. My name figures it.
Based on confidential
It is
information.
suspected that,
So,
along with others. Now, those two players, Your Lordship, Mukhtar Hussain and Mimoy Datta, Your Lordship, against whom they have, who have indulged in on-field while game was going on, Your Lordship. Yet, with regard to them, Your Lordship, kindly see Annexure 2, page number 43, Your Lordship. Last page, Lordship, page number 43.
43.
Main persons, Your Lordship. It has been issued on 19/12/2025. The following players, this is the squad for Vijay Hazare Trophy, Your Lordship. The following players have been selected to represent Assam state team for the Vijay Hazare Trophy one-day tournament 2025-26 to be held from 24th of December 2025 at Rajkot. Lordship may kindly see at serial number 12, Mukhtar Hussain. His name is also figured in the squad, Your Lordship. Against whom, Your Lordship, they have done on-field, Your Lordship, observation. And merely on suspicion, Your Lordship. Even after that, Your Lordship, they are being included in the squad. This is the case, Lordship. I am paying for interim order.
No, this is
One Mukhtar Hussain and Mimoy Datta. Mimoy Datta was a standby player in that Vijay Hazare Trophy.
your submission, please. Motion stays.
Yes, motion stays, my lord.
One person, namely Omid Sinha, has already been granted bail, Your Lordship, interim.
Yes, yes, I think.
Indemnity.
You have the order.
Yes.
I think, his name figures for the first time in para 6.
Yes, yes, Lordship. Page number 27, Your Lordship, last para, conclusion. All of them, Your Lordship. Page number 27, last para, Your Lordship. Based on confidential information received, it is suspected that
Marked it.
Omid Sinha, Abhishek Thakuri, Ihsan Ahmed and Aman Tripathi. My name is figured in the inquiry report, Your Lordship.
Petitioner is also, my lord, FIR name also.
Yes, all of them are FIR named, Your Lordship.
FIR name.
Yes, Lordship, all of them. 4 persons, Omid Sinha, Abhishek Thakuri, Ihsan Ahmed and Aman Tripathi. The persons, Your Lordship, Mukhtar Hussain and Mimoy Datta. Even after that, Your Lordship, on 19/12/2025, when subsequent squad for Vijay Hazare Trophy was formed, Your Lordship, their name figured in the squad list. They are representing the state of Assam, Your Lordship, in Vijay Hazare Trophy.
Anyway, let me also record the statement. Your good name, please.
R.A. Chaudhary, Your Lordship.
R.H. Translate. And additional people. Your question. I'll record your objection.
Yes.
For order to add apart law. It will. Petitioner. There are two numbering 1 and 2, 3, 4. Stop. The Mr. Chaudhary, the learned counsel for the petitioner, submits that though he has been named in the FIR, but the inquiry conducted by the BCCI reveals his name only in para, only in the conclusions against serial number 5, 6. wherein it is stated that dash based on confidential information. Confidential information, this one. So and so it is suspected that so and so Ishana made with players. Full stop. It has also been stated in the report that while no conclusive evidence of at this stage, so and so on. It is submitted by the learned counsel that to Amit Sinha, co-accused Amit Sinha, who similarly placed, was granted interim protection by order dated 19/12/25, passed in AB 3028 of 25, passed by this court with conditions, including appearing before the IO for recording his statement. It is also submitted, drawing attention to Annexure 2. It is submitted that though co-accused Mukhtar Hussain has
He's not offended with his donation.
He's not offended.
He is on-field player who has done corrupt practice.
Nothing not to mention.
Right.
He's just been selected.
Yes.
He says he wanted to make out. Anyway, you record your statement. We'll see later on. The learned additional PP opposes the grant of interim protection. Upon perusing the materials and finding the present petitioner also to be similarly placed as the co-accused granted interim bail as mentioned above, dash that is. I am inclined to grant a similar relief to this petition as well. However, call for the case diary of so and so. This is fixed on 9/1.
9. Can it be after?
Yeah. However, in the interim, we have to outside loan. Okay, same conditions. 30,000 with 1 COD. Okay. You shall cooperate with the investigation. And you will appear within this week. You appear. Get this.
He's from Dibrugarh, Your Lordship.
Huh?
Within 2-3 days, Your Lordship, I appear.
Yes.
Sometime, Your Lordship.
It is next date is fixed on 1.
1 Your Lordship.
If you can appear within this, where does he stay? This person?
Dibrugarh, Your Lordship.
Dibrugarh.
Yes.
Next date is fixed, my lord.
9/1.
9.
Friday.
9/1.
Friday. He'll cooperate with the investigation and get us. And he shall not hamper or tamper with it.
9/1. Right.
Friday.
Yes,
Friday.
Interim decision.
After vacation.
After vacation.
Vacation.
But the diary might come.
Oh,
on
my lord.
9/1.
There is.
So far as I am concerned, Your Lordship, after vacation. This is my humble submission.
Okay. 21.
Obliged.
21 or 22? 21. 21. 21/1.
Obliged.
Then you do tell about it. I appear before the IO and recording.
Time being 27.
Okay.
Make your lordship.
7 to 38. I'm good.
Lordship, can copy your sponsor in this matter, your lordship. Your lordship, the petitioner, your lordship, you received notice, your lordship, didn't appear before the trial court, your lordship. Thereafter, your lordship, BW was issued, thereafter NBW, and then PNA was issued, your lordship. At the first instance, your lordship, he has contacted some counsel, and due to some miscommunication, steps were not taken, your lordship. When he came to know, your lordship, that he has been seriously missing those dates, your lordship, he voluntarily appeared before the court on 22/9, along with a bail application, your lordship. And your lordship, that bail application has been denied and he has been taken into custody, your lordship, on 22/9/2025, your lordship. And since then, he is behind the bar, your lordship. He is willing to participate, your lordship, in the trial, your lordship. He has filed another bail application on 16/10, your lordship. Both the applications are annexed in my petition, your lordship. That has also been rejected, your lordship.
Actually, earlier PNA was also issued.
Yes,
Therefore, the trial court
Yes, your
rejected.
lordship.
Or the court below rejected. Session judge.
So this, as of today, he is behind the bar since 105 days, your lordship. All the other accused are now, lordship, they are participating in the trial. He also intends to,
They are on bail.
they are on bail.
Lordship, may I kindly peruse the order dated 8/8/2025, my lord, from the scanned copy of the record as well as my lord, the petition also, my lord. Page number 26, my lord.
8/8.
Page number 26, 8/8/2025, my lord. Case record put up before me as the learned presiding officer is on transit leave. Accused Purnima Das is absent with steps by filing petition showing cause of her absence today and praying for fixing another date. Seeing the petition heard both sides, peruse the case record and considering all the petition is allowed. Accused Babdon alias Nozrul and Pooja Bordol are absent without any steps. NBWA issued against accused Babdon alias Nozrul has returned with its report. Seeing the report, considering the said report, issue NBWA and PNA against the accused Babdon alias Nozrul. Seen issued, someone issued to accuse Pooja Bordol has not returned. Issue fresh notice. Then lordship might kindly peruse the next order, my lord.
Yes.
Page number 27, my lord.
22/9.
22/9, my lord. Page number 27. On that day, my lord, the accused person, he appeared, my lord, and he was taken into custody, my lord. Now, the fact is that, my lord, after receiving, my lord, NBWA as well as PNA, my lord, because the learned trial court has taken him into custody, my lord, after, my lord, since he has avoided arrest, my lord, intentionally, my lord.
Court was justified.
It's justified, my lord.
So I don't.
Because yesterday there's nothing wrong with the order actually.
And it is a, my lord, long pending case, my lord. The charge sheet was submitted long back, my lord. This is a FIR, my lord, is of,
Just
my lord,
imagine.
2017, my lord.
Will he appear now?
Yes, your lordship. And your lordship, another accused Pooja Bordol, your lordship, not just because of him, it has been another accused Pooja Bordol, she has also not appeared, your lordship. So
Now she has
again,
appeared.
She has also not appeared, Pooja Bordol.
Yes.
So because of how also, your lordship, it has
They
been.
escaped actually
Yes.
to some extent. Anyway.
No, with some strict condition, my lord, because he may again, my lord, evade it.
Your lordship,
My lord,
I
appearing.
voluntarily appeared on 22/9, your lordship. I was not
That will not
apprehended.
help him if he evades again.
Yes, sir.
Because it will be very difficult to get bail again if he evades again.
My lord, definitely. There may be some strict condition, my lord.
The earlier times are not there. Nowadays, it is not possible for anyone to, abscond and disappear because
Yes,
all the records are there.
Yes.
Everything the records are there. People can be tracked. As I say jokingly, unless you are a woodcutter in a very deep forest, or something, then you may disappear.
My lord, CS file in the year 2018, my lord.
Yes,
Since
yes.
then, my lord, it is pending for appearance, my lord. It's more than 7 years, my lord.
That is why they have been, But again, this will be the last time actually. But that's why, in a way, and trial has not started.
No, your lordship. Trial has not yet.
It is
started.
still in the appearance stage, my lord. That is.
Coercive measures should be taken earlier also, actually, this time. Since invoking 483, the petitioner Nazrul Hussain alias Babdhan, seeking regular bail in connection with Sessions case number 165 of 24 under section 370/371 IPC. And which arose out of Tezpur PS case number 1501 of 2017. Full stop. It is stated that the case is at the stage of appearance. The next date is fixed. Tomorrow, that
Tomorrow, yes.
6/12/2020. No, not tomorrow. Not 12. 6/12. It's over.
Yes, your lordship.
I also thought like that. You don't know the next date, right?
Lordship,
No
I
idea.
brought it here, 6/12, your lordship. This written on
It's past only. Next date. The case is at the stage of appearance. And the FIR is dated 29/7/2017 itself. And charge sheet was submitted on.
Charge sheet submitted, my lord, that is,
No,
my lord, in the year 2018, my lord.
The charge sheet submitted in 2018. Full stop. Due to non-appearance of the petitioner, NBW and PNA was issued. And subsequently on 22/9, he voluntarily appeared. That is the only good thing in his favor, that he appeared himself.
There is no option left, my lord. That is
No
why
option left.
that is why he appeared.
But still, that is, whatever good is, has to be appreciated, should be appreciated. Yeah. But he was left with no option. On 22/9/2025, and sought bail, but the same was rejected by the learned trial court, considering the earlier conduct. Good stuff. It is submitted on behalf of the accused, the said accused petitioner, that he is willing to participate in the trial and cooperate before the learned court below. The trial and the proceedings before the learned court below has already got delayed, and therefore, if the attendance of the petitioner can be secured by granting him bail with conditions, perhaps that might be in the larger interest of the trial. Full stop. The scanned copy has been received and relevant portions perused. Full stop. Heard, the learned additional PP points out the non-appearance of the, points out the earlier, another order dated 8/8/2025, whereby NBW and PNA were issued against the accused. In the given
Prior to that also, my lord, it was issued, my lord. 8/8 is the one order, my lord. Last order he has NH, my lord. But even prior to that, my lord, NBW and PNA was issued, my lord.
Was issued, even prior to that, NBW and PNA were issued.
My lord, 8/8, my lord, only NBW, my lord. After 8/8, my lord,
PNA.
NBW as well as PNA was issued, my lord.
Earlier, earlier dates also, NBW was issued against him, PNA. In the given facts and circumstances, and to facilitate the trial, the accused is hereby allowed to go on bail of rupees 40,000 with one security of the like amount, to the satisfaction of the concerned learned court, and subject to the conditions that he shall not abscond. Number two, he shall be available before the learned trial court and participate in the trial. Number three, he shall not hamper or tamper with evidence. In case of violation of the bail conditions, the bail shall be liable to be cancelled. Bail petition stands allowed and disposed.
Like the motion.
Finding 38.
Waited for a long time. Waited for a long time. Could you see that?
Yes, my lord, here I have gone through that, my lord,
Not
and
that.
my lord, here the case, what my lord has suggested is similar in the way, my lord. Though my lord, his name is not searched, my lord. They, my lord, keep the investigation open, and my lord, there is the additional search sheet will be filed, my lord. Then, my lord, from the statement of the my lord, there is the co-accused, my lord, his name came out, my lord. So it is a, my lord, there is a very serious allegation.
Reflected, no?
Yes, my lord, it is reflected, and they said they tried to, my lord, find him out, my lord. They went to his residence also. They are not able to come. Along with him, another co-accused is also there.
He is on interim bail,
My lord.
isn't it?
Yes, my lord. So, my lord, not at this stage, my lord. Not at this stage, my lord. Because, my lord, they keep this open, my lord. I have, my lord, flag mark all relevant portions, my lord.
So, you are proposing dismissal of the petition, or keep it
Yes, my
pending and wait for the further investigation?
My lord, then there will take time, my lord. In these cases, my lord, when such serious allegation is there, my lord, in these cases, my lord, very much custodial interrogation is required, my lord. And my lord, that is the crime scene, my lord, what has come out, my lord, that my lord, the allegations is very serious, my lord. How the modus operandi, how they are taking care. There's a sane system, my lord. Entire scene, my lord.
180 statement also.
Because my lord, arms sec is also there, and he is the person who's provide the arms, my lord, as the allegation is that, my lord. So many things may, my lord, may come out, my lord, from the investigation. Some horizontal flag marks are also there, my lord. My lord, may kindly peruse those persons, those are relevant persons.
Apart from these statements,
My lord.
any witness statement is there?
My lord, here, my lord, because the case is that, my lord, that is,
Witness
they
statement.
destroyed the, my lord,
180
CCTV also, my lord.
180 statement is there. 180, 161 statement.
Yes, my lord.
Of one witness, one say.
Because my lord, witness didn't notice, my lord, but they are all persons, my lord. And my lord, that the CCTV which was present there, that was, my lord, destroyed, my lord. That part is also there, my lord, from the statement of the victim, and also, my lord, that is the one of the, my lord, grandchild of the, my lord, that is the victim, my lord. That statement is very much clear. Now, my lord, during the course of interrogation, my lord, it has come to light that he and another with another co-accused also there, my lord. The police didn't get them, my lord. So, my lord, they kept it open, my lord, to file, my lord, additional charge sheet, my lord. So in this case, my lord, at this stage, my lord, our humble prayer is that, my lord, may not be, my lord, granted, my lord.
Heard, Chancellor.
May I, Lordship?
Yes, you can reply.
Lordship, all the four accused, Lordship, it is stated in the forensic report that following the CCTV footage, Lordship, all of them were identified and arrested, Lordship. So, Lordship, the strange CCTV footage is whether it is true or false, I don't know, Lordship. But they were arrested following CCTV footage. It is there in forwarding report, Lordship. And Lordship, the statement of a accused, Lordship, co-accused, that is confessional statement, Lordship. That cannot be evidence,
That
Lordship.
is true.
In trial also, Lordship.
What is the witness statements are, they have also stated on this.
So witness
Similar.
statements are
They
there.
have to-
If, my lord, my learned friend, my lord, give, my lord, impression upon that, then, my lord, entire CD is needed. That is the entry, my lord. How, my lord, what is, my lord, recovered? Here, my lord, in the, my lord, that is the search sheet, my lord. Some, my lord, matte evidences are there, my lord. But, my lord, from there, one, my lord, that is a pen drive is also there. But from there, we are not able to see, my lord, whether it is the, my lord, those are the pen drive related to the footage of the, my lord, that is CCTV or not, my lord. And, my lord, this is not the complete, my lord, that is the case diary, my lord.
Lordship, prosecution has to establish, Lordship,
My lord,
whether
it's
prima
like-
facie I am.
Prima facie, my lord, to tell, my lord, in
Lordship,
those cases, my lord, when
or
dacoity,
not-
robbery or extortion, my lord, in
And they are
those
just-
cases, my lord, even, my lord, arms, my lord, is found, my lord. In those cases, my lord, many things may come out in the course of investigation. So though, my lord, that is the search sheet is filed, my lord, that for the present instant case, my lord, for this accused, my lord, so it is, my lord, still, my lord, it will take time, my lord.
Lordship, in your Lordship, in the first order, Lordship, in this application, your Lordship give a chance, Lordship, to the petitioner to appear before the IO and give his statement, Lordship.
Anyway,
If
so-
the investigation is not complete, that may be given, Lordship.
It will. আগৰ 1/11/2025 second third paragraph to the fourth 2 3 4 stop. For certain for the reasons stated in the order dated 1/11/2025, the petitioner was granted interim bail with conditions. In the meantime, the scan case record has been received. It is submitted by the learned additional PD that though one charge sheet has been submitted in which the present petitioner has not been sent up for trial, but further investigation into the case, into the alleged offences are on and including including investigation into the role of the present petitioner, who has been mentioned as the main mastermind behind the alleged offense of robbery. Full stop. It is submitted by the learned additional PP that the investigation, the statements of co-accused does indicate the role of the present petitioner. In this context, the learned petitioner counsel submits that the statements of the co-accused should not be admissible. Full stop. I have also seen the statements of the two witnesses, including one victim, which was recorded by police during investigation. Full stop. It is submitted by the learned additional PP that, considering the nature of the allegations, nature of the alleged offenses, nature of the alleged offenses, the perhaps custodial examination of the petitioner would be necessary as part of effective further investigation. Upon considering the materials, I find force in the said submission, and perhaps at this stage it may not be an appropriate case for granting anticipatory bail. Therefore, the interim bail stands vacated and the instant petition for anticipatory bail stands rejected at this stage.
Lordship, I have submitted a order passed by your
Yes.
lordship, but in that order, Lordship, without going to the merit of the
Yeah,
case.
it depends, sometimes.
Is Lordship willing to appear?
Sometimes that's
Lordship,
why
as
it is
a
always
trial
risky. No, if it's a kind of, it is always, if you
Lordship.
go
My
to merit,
suggestion is
sometimes
that,
things
Lordship,
emerge.
they have to establish my involvement, Lordship,
That's
whether
true.
by telephonic conversation or so and so, Lordship.
But let them investigate, because in the initial forwarding only he was referred to as the prime minor, which finds some support from the matrix.
He may be given a chance to appear before the your lordship. So lordship, given in earlier order.
Let it be. At this stage later, you can file it later if necessary.
Obliged.
May it please your lordship. Lordship, this is a regular bail application. What happened, lordship, will find the FIR on page 16, lordship. The police in civil dress, lordship, picked up one person, lordship.
New matter.
Page 16, lordship. Page 16 is the FIR, lordship. Though this petitioner are named in the name of the accused, FIR name accused, but in the body of the petition, lordship, FIR, there is no specific allegation against this petitioner, lordship. May I read the FIR, lordship? It is respectfully submitted that on 27/12/2025 evening at about 6:10 p.m. in connection with the Bhiwpuria PS case number such and such, the officer in charge of Bhiwpuria Police Station ordered the arrest of accused Baharul Islam alias Ambani on 13th Battalion APBN staff along with the driver of a private vehicle such and such in a civil cloth and arrested the accused in front of the garment shop situated at Ramjan Tinal. Immediately the accused started hue and cry and started to abuse the police personnel with filthy language and derogated language, and thereafter the large group of people suspected to be involved in the nexus of a fake gold and fake currency assemble and attack us with a sharp weapon with a view to kill us and thereby cause grievous injury to us. The group then snatched the apprehended individual from the police and vandalized the vehicle of the police use and severely injured the driver, lordship. What happened, lordship, in this case? The police personnel came in a civil dress, lordship. They have picked up a person, lordship. At that time, lordship, cricket match was going on there nearby area, lordship. He raised hue and cry, lordship. Then those people come, lordship. They say you have to show your identity because you picked up a person without showing your identity. That's why, lordship, all the person who has obstructed the police, they are now, lordship, arrested, lordship. Now this present petitioner is the, lordship, accused number 2 and 4 of the FIR. In the forwarding report, lordship, will find on page 19, lordship. And some of the co-accused, lordship, approached for the bail for the court below, lordship. Their bail was rejected, lordship. I have annexed that copy also, lordship. But the private person whose vehicle was damaged, lordship, he has not come up, lordship.
So he was arrested on same day.
Oh yes, lordship, on 13/12, lordship. Forwarding report on page 9,
19 Lordship. This is the case, Lordship. They have to disclose they are the police personnel, otherwise, Lordship, the people will not, Lordship, obstruct them to arrest those persons, Lordship. That is not reflected in the FIR, Lordship.
I see. And big reflect currency.
Para 4 in my petition, Lordship, I have stated, Lordship.
Otherwise,
Page 5, Lordship.
you have taken notice.
Yes, I have
Pa-
perused the FIR, my lord.
Mhm.
In the, my lord,
Which
The-
Thana, let you get the case diary.
In the meantime,
Bipuri.
Lordship, some protection
Okay.
will be the interim protection, Lordship.
We-
Because, Lordship,
No, he is arrested, right?
they are arrested, Lordship. But,
Because-
Lordship, the co-accused, Lordship, their rejection, Lordship, will find on page, I have annexed, Lordship, that order, Lordship. Page 22, Lordship.
we can try on 9th, my lord.
8.
8.
Ninth, I am keeping, largely we
Minor.
should always keep it flexible.
My lord.
Space, we should keep
8,
some
my lord.
space. Whatever comes at the last stage, we can fix.
Lordship, kindly
Hmm.
come to the page 26, second paragraph, Lordship. Page 26, second paragraph, Lordship.
Hmm.
I have gone through the ground of arrest and the considering the statement of the witness recorded under 180 BNS 2023, there are reasonable ground to believe that the accused person might have involved in the Ellis offense. Further, IO has produced before me a video footage from his mobile phone, which showed that the arrested accused person were present at the place of occurrence. Mere presence may not be the lordship taking part in the activities, lordship. This is the ground, lordship.
Present and found to be involved.
Yes,
Whatever it
at least to be found.
we do not know. Let us get the diary at this stage. Before.
In the meantime, interim lordship,
Interim would be
because
difficult.
they are in jail, lordship, because of they are the actually the spectator of this lordship
Regular
cricket
bail,
match,
there has
lordship.
to be some reason for.
Yes, lordship.
For regular bail interim, isn't it? Call for the case diary of third. B. Chaudhary and R.J. Boros. Call for the case diary of Bipuria, PS case number 244 of 2025. Accused person was arrested on 30/12/2025. After the case was registered based on FIR dated 28/12/2025. Lost by SI Gokul Jaisi. Gokul Jaisi of Bipuria PS. Stop. This is the matter of 919.
Can it be on the 8th, lordship?
8 or 9.
My lord, I am praying for 9th, my lord.
They did not.
Nine.
Not fixed so far. Well, I think one matter.
9-1, my lord.
Highly obliged.
Okay, see.
Petition item 21.
But here we are respondent here.
Mhm.
It was a case, division was filed by the husband for maintenance. It was in the year 2015. And present status, I have no knowledge, and the petitioner's advocate is also not present today.
In 2015 only, no?
Yes.
Year for the respondent.
I propose to write a letter to the respondent to get the information. I don't have the phone number also.
So your client, you not in touch?
No.
Oh. That's the only option then. You have also not appeared. So you do not know also that whether she is
Yes,
getting that.
yes. Whether they are living together or in separation. That's why I hope my,
And
after 2 weeks, Melody, if it comes, and I can.
after
Weeks.
say last week of January or
Yes,
third week
yes,
of-
yes. I'll write letter today itself. With this
Postal
postal
None
address.
appears today on behalf of the petition. The S.T. Biswas Learned Counsel appears for respondent number 2. Who stated to be the first first party in CR case number 301 of 2013 under the DV Act. Before the learned LBJM M. Bijni, the district of Chirang. The petitioner has challenged the judgment and order dated 30/12/2014, granting monthly maintenance of rupees 1,500 to the respondent number 2. So, Mr. Biswas Learned Counsel submits that at present he doesn't the said litigant has also not communicated with him, and that he may be given some time to get in touch. The prayer is allowed. List the matter in the last week of January on the date. It's the date, right? 29. 29/1, sir? Is it
Yes.
okay? All matter, no, we should fix it, finish it. So,
32.
My lord, this case is also 2015.
Yes.
Yes.
Amazing. Last date is order is of 2016.
Yes. My lord, whether, what is the status, I do not know.
lost
Give me
it.
same similar order me first, I'll write letter to her.
Here you are the petitioner, right?
Yes, I am petitioner here.
The two petitioners has invoked the inherent jurisdiction under 482 CRPC within bracket as it existed then for quashing of charge sheet dated 11/1/25 submitted after investigation in Patasil Ambari PS case number 563 of 14. Full stop. The charge sheet was stated to be submitted before learned CJM Kamrup M. Guwahati. Full stop. Mr. S.C. Biswas, Mr. Biswas, learned counsel for the petitioner, submits that the communication proceeds sometime. None appears on behalf of the respondent number 2, the informant. No?
Yes.
She must have been the informant. Full stop. Same date
Yes, same day.
for your convenience.
I'll write, it is from Guwahati only.
29/1.
Yes.
33.
Well, the track record of this case is also somewhat similar to the previous two cases.
All are coming together.
Only thing is that, my lord,
Old
I could not establish any contact with the petitioners. It was a case under 498A, and the conviction was of 3 months.
It is the duty of the person litigant to
That,
get in touch with the.
but I have
to
lost.
go to the doctor will
Yes.
come to me.
But
But anyway, so.
so if your lordship wants to take up the matter, my lord, I am otherwise, I can otherwise address your lordship on that. But
let
the
me see.
respondent number, the informant
But
was
you don't
also.
have any instruction.
Yes,
Let
the
me see.
informant was also made a party. She also has not appeared because at the time of trial itself, my lord, it appeared that she had left the association of the petitioner and she was settled in Delhi. So I think, my lord, by this time,
This is against revision against conviction.
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 I think, my lord, by this time,
It's good if we can dispose of these old matters,
yes.
but it is always good. But let me just, because it's for me, it's new. So it is, he was convicted under 498A.
498A.
Appeal was dismissed. 3 months.
3 months SI with 5,000 rupees, fine. Well, the basic grounds are that, my lord, there are apparent contradictions in the testimony of the witnesses. There are only 3 witnesses, so to say, barring the official witnesses. The informant is the victim herself and her parents. These are the 3 witnesses in the case.
So, what do you suggest? Should we
My lord,
go into it?
my lord, your lordship may look into it, my lord. The only thing is that, my lord, there is some handicap on my part because I have also misplaced the trial court record, so to say, the text of the evidence. If your lordship permits me, my lord, I can read it out from the trial court record there.
Lordship, I have to go through the case record, Lordship.
But if I can, without opening the file, my lord, if I can give an outline, my lord, I think, my lord, it will be clear. The marriage was solemnized on 25th of January, and it did last only for 5 months.
You take it up. Not full. Yeah, just. Let's try then.
Well, the marriage was solemnized on 25th of January 2008. And it did last for only up to 28th of May 2008, when the informant left the association.
Marriage was solemnized on
25th of January 2008.
25/1/2008.
Yes. And the date of incident is 28th of May 2008.
When she left.
When she left. This
Never returned.
never returned. And in the evidence, she said that she has settled at Delhi, pursuing some vocation, some studies, etc. The parents have also repeated the same thing in the evidence, so far as her going to Delhi is concerned. Well, my understanding is that, well, perhaps by this time they have found out the better avenues in life, and therefore they have lost interest in the matter.
And what about their marriage?
But
Marriage is still so
marriage, that is the tricky area, because from neither could I gather any information whether the marriage ended in any divorce or not. The petitioner number 1 being a male, my lord, by under his customary law, he can marry for the second time or third time. But I do not know about the informant. The petitioner number 2 is the sister-in-law. Although the allegations,
educated sections usually they don't do that.
yes, usually, my lord, the allegations were against all the members of the family. The father-in-law, son-in-law, mother-in-law, sisters-in-law and all. But ultimately the charge sheet was laid against only the petitioner number 1, who is the husband, and the petitioner number 2, who was the sister-in-law.
Sitara Begum.
Yes.
Sitara Begum.
No, Sitara Begum, there was allegation, but she was acquitted. Rashida Begum is the sister-in-law, who is the petitioner number 2. Now she is also convicted. Now, the only incident that happened on 28th of May 2008 is that, my lord, as per the allegation goes in the FIR as well as the evidence, there was a quarrel in the house on the pretext that she was required to bring some more money. The allegation is that there was a demand for dowry, and she was required to bring some more money. Belies the contention that there was demand of dowry from day 7. Because the victim says in her FIR as well as in the evidence that from day 7 after marriage, that will be around 2nd or 3rd of February 2008, there was demand of marriage. But this aspect is belied by the testimony of the father. Your father says that for about 5 months, it was absolutely fine. At one point of time, my daughter told me that the the groom needed some money for investment in his business. I gave it to my daughter. She might have given it to the husband. That is the chain as far as the payment of money is concerned. I'll take your lordship directly to the evidence, my lord, if your lordship will.
How many we examined?
3.
3.
And the other 2 were, my lord, the IO and medical officer. That makes it 5.
That's a 3 plus 2.
3 plus 2. Primary witnesses are these 3, the victim, PW1, father and mother, PW2 and 3, and medical officer is IO is PW4, medical officer is PW5. Now, there is also discrepancy in the sense that, my lord, when she was describing the cause leading to filing of the FIR, the process leading to filing of the FIR, she says that on 28th of May 2008, there was the assault of incident of assault. I made a call to my parents' house.
On 28.
On 28.
28.
28/05/2008. She says that there was an incident of assault I made a call to my parents' house. Parents' house, her matrimonial house is at 6 Mile. Parents' house at Machkua. Now she says in the evidence that at about 1 p.m. in the noon, there was an assault. I made a phone call to my house. Parents also came there at 1 p.m. and took me there. They highly improbable. Because from 6 Mile to Machkua, my lord, it will not be anything less than 20 minutes, even on a free road. Now, this is her version. Her father says, PW2 says that no, I did not go to bring my daughter. It was my wife who went and brought her back. I do not know whether, the father says that I do not know whether on their way return they visited any doctor or not. I do not know whether on their way return they visited any police station to lodge FIR or not. So he does not support that way the prosecution story, the victim's story, that there was an incident pursuant to which she made a call. The parents came and took her away, and on the way they got her examined at Mohan Raman Chaudhary hospital. So this is the discrepancy so far as PW1 and PW2. Now, as far as payment of money is concerned, there are two aspects of it. She also says that in total 2 lakhs were paid to the husband, that is petitioner number 1. And 1 lakh I paid out of my own savings, 1 lakh I paid from my father's payments. Now, her father says, PW2 says that I paid 1 lakh rupees to my daughter, and my daughter might have paid it to the petitioner number 1, but it was taken from me on the pretext that it was to be invested in the business. Now, if that is the story, my lord, then in my respective submission, the aspect of dowry takes somewhat a backseat. Because it is an admitted position, it becomes an admitted position that the money was taken for investment in the business. Now, if you're now, in the evidence, my lord, evidence of PW1, which will be at page 18.
Page 18 of the
Page 18 of this, my lord,
compilation.
Trial court record, my lord. Now, here she says that I am staying at Delhi and I am prosecuting some studies. That was long time back. The case is of 2008 and we are in 2026 now. And the PW2 also says, whose evidence will be at page 19, that they were happily married for about 5 months. They went for a honeymoon to Kashmir on a trip. But thereafter, the demand, and he also says that the money that I have paid was prior to the date on which my daughter was tortured. That is also his statement. So the projection of the prosecution is not with a very definite particulars, so to say, as to who had committed the assault, particularly linked to the injury. It's a general kind of a statement that they all together assaulted me. But as to who had committed the injury on forehead or maybe on the nose, or because the one allegation is very specific that the sister-in-law had threw a bunch of keys, keys in a key ring to the informant for which she sustained some injury on her lips. That was the allegation, but in the medical report there is no mention of this kind of an injury. So the possibility of some injury having occurred to her after she left the matrimonial home, that also could not be reduced. The trial court's only observation is that since it's a matrimonial dispute and concerning the parties at a very earlier point of time, so probation of offenders, I will not also extend the benefit of probation of offenders. That is the reason based on which, my lord, the judgment has been, the punishment has been imposed. If your lordship will kindly see page 23 of this appeal memo, the revision petition, my lord. page 23 makes a reference of the evidence of the
Doctor.
paragraph 10,
Yes, yes.
and there the injuries are mentioned: abrasion on forehead, abrasion over sternum, and bruised black
As you
condition.
know, the revisional jurisdiction in
Yeah.
conviction. So we have to broadly see whether, not
Yes.
take an appeal. So broadly, we have to see whether.
There is perversity or
Yeah,
perversity or finding or not.
Okay.
So, my lord, my submission.
Could you read
Lordship will try.
to some extent?
Yes.
Well, I tried with my limited eyesight, my
No.
lord. 1 and 2, it can be managed somehow.
Yes.
3, my lord, it is very difficult.
Lordship.
Tree is, whose tree?
Three is-
3 is the mother.
Mother, her mother.
Yes.
And 4, 5 are
4 is the IO, 5 is the doctor.
doctor. They are legible.
They are somewhat legible, but their evidence is mostly reflected in the judgment.
Yeah.
So that is only to the extent that on particular day I was at the PS, I received the FIR, case was registered. That does not.
4 is Lordship handwriting.
No, 4 is still somewhat legible, but 3 is very difficult.
4 is doctor.
No, 4 is IO,
I
5 is doctor.
5 is doctor.
handwriting will work, yeah.
ধরাই যায় না কিছু এটা এটাতে তার মধ্যে যদি আরো পাওয়া
Are you in a position to say whether they were arrested during the time, at that time?
They were arrested but released on bail, and because of the order passed by this honorable court, they are continuing on previous bail.
Yes.
Initially arrested on the registration of the FIR, but immediately thereafter released on bail. And your lordship will kindly see the order of 20th April.
How long they were in custody during this time? No idea.
No idea, but may not be more than a week or so, because during the trial also they were on bail.
Yes, yes. Usually in these cases, you are on bail during trial.
Because it was 498A and 34, but 34 was omitted later. It was only 498A. So practically, my lord, the case is case of the petitioner's case projected in the revision is based on the apparent contradiction in the testimony of the 3 witnesses. Well, the chain of events as is depicted by the victim, that is not that way supported by the other 2 witnesses. They are saying different stories at different places. Very importantly, the PW2, who is the father of the victim, he got his statement recorded under 161. But in the evidence, he says that I have not given any statement before the police.
2 DWs also were examined.
There were 2 DWs also.
Yes,
You found the DWs.
TWs. DW1. Jalil Ahmed.
The PW2 says that they were happily married for 5 months. The PW1 says we were having a good time only for about 7 days, because after 7 days the torture and demand of dowry, etc. started. Now PWT2, who is the father and who happens to had given the money, he says in his evidence that I had given the money before the tortures and other things had come. PW2's evidence, your lordship will kindly see. That will be at page.
Record is with. You can read it from there.
Well, if I can read it out.
You can read.
I am reading the evidence of PW2 father. Taslima Ahmed মোর ছোৱালী 25/1/2008 ইংৰাজী তাৰিখে মোৰ ছোৱালীৰ বিয়া পদকীয়া হিলালৰ লগত হয়। তেওঁলোকে 5 মাহ একেলগে ভালকে থাকিলে। 6 মাইলত হিলালৰ ঘৰ। তাৰ পিছত পদকীয়া হিলাল আৰু তেওঁৰ পৰিয়ালৰ সদস্যবিলাকে মোৰ ছোৱালীক অত্যাচাৰ কৰা আৰম্ভ কৰে। বিয়াৰ পিছত মোৰ ছোৱালী 1 লাখ টকা লয় আৰু মই 1 লাখ টকা দিছো। More Swali, now the other in the PW1 says the demand was for 2 lakhs.
2 lakhs.
Now he says that মই 1 লাখ টকা দিছো। মোৰ ছোৱালীক মাৰপিট কৰিবলৈ ধৰাৰ আগতে উক্ত টকা দিছো। So that is his evidence in chief. পদকীয়া 5 লাখ টকা দাবী কৰি অত্যাচাৰ কৰে টকা দিব নোৱাৰিলো কাৰণে মোৰ ছোৱালীক মাৰপিট অত্যাচাৰ কৰে ছোৱালী মোক ফোন কৰি খবৰ দিয়াত আমি গৈ ছোৱালীক লৈ আহোঁ পদকীয়াৰ ঘৰৰ পৰা আৰু ছোৱালীজনীক ল'ব অহা নাই খবৰো কৰা নাই ছোৱালীজনী বৰ্তমানে দিল্লীত থাকে চাকৰি কৰে so that was 2012 now in cross he says মই মোৰ ছোৱালীৰ হৈ সাক্ষ্য দিবলৈ আহিছো ছোৱালী এজাহাৰত কি লিখিছে মই নাজানো মই ছোৱালীৰ লগত থানাত যোৱা নাই মোৰ পত্নী গৈছিলে প্ৰথম 5 মাহ আমাৰ দুটা পৰিয়ালৰ মাজত অহা যোৱাৰ সম্পৰ্ক আছিল বিয়াৰ পাছত মোৰ ছোৱালী আৰু জোৱাই হানিমুনত কাশ্মীৰ গৈছিল বিয়াৰ কিমান দিন পিছত গৈছে মনত নাই বিয়াৰ আগতে মোৰ ছোৱালী ঘৰতে টিউচন কৰিছিলে 28 মে 2008 ইংৰাজী তাৰিখৰ পৰা ছোৱালী আমাৰ ঘৰত পুনৰাই থাকিব আৰম্ভ কৰে ছোৱালীজনীক ঘূৰাই আনিবলৈ যাওঁতে মই নাছিলো ছোৱালীজনীক তাইৰ মাক ফোন কৰি খবৰ দিছিল ছোৱালীজনী কি কৈছিলে নাজানো ফোন যেতিয়া আহে মই ঘৰতে নাছিলো ছোৱালীজনী ঘূৰি অহাৰ পিছত তাইৰ ওপৰত হোৱা মাৰপিট অত্যাচাৰৰ কথা জানিব পাৰো so before she came back there was no discussion even amongst the PW2 or 3 or PW1 that there was some incident of demand of dowry or etc so therefore he says that whatever money I had paid to my daughter that was for the purpose of making investment in the business and before this incident 2008 28th of May 2008 had taken place ছোৱালীজনী আহতে পাটতে কোনোবা পুলিশ ষ্টেচন সোমাই এজাহাৰ দিছে নেকি মই নাজানো মই পুলিশৰ আগত স্টেটমেন্ট দিয়া নাই now this is again a contradiction he has given a statement under 161 but he declines to admit that in the examination in chief in cross টকা মই ছোৱালীক দিছো 28 মে 2008 তাৰিখে কেইটা বজাত ঘটনা ঘটিছে মই নাজানো মই নাজানো কেছ দিয়াৰ আগতে বা পিছতে ছোৱালীজনী ডাক্তৰৰ ওচৰত গৈছিল না নাই মই মোৰ SBI একাউণ্টৰ পৰা টকা উইথড্ৰ কৰি দিছো 1 লাখ টকা উইথড্ৰ কৰি দিছো ছোৱালীজনী নিজৰ একাউণ্টৰ পৰা টকা দিছিলে পদকীয়া খিলালে 5 লাখ টকা ছোৱালীৰ পৰা দাবী কৰিছিলে সত্য নহয় যে মই মোৰ ছোৱালীৰ খাতিৰত মিছা সাক্ষ্য দিবলৈ আহিছো সত্য নহয় যে মই বা মোৰ ছোৱালী 1 লাখ টকা দিয়াৰ কথাটো মিছা সত্য নহয় যে হিলালে মোৰ ছোৱালীক মাৰপিট কৰাৰ কথা মিছা সত্য নহয় যে 5 লাখ টকা দাবী কৰাৰ কথা মিছা this is PW2 and PW3 is very difficult although Milord I'll try to
victim
I am reading out
let us read that
the victim's statement
IOI will not medical it is already reflected as
it is reflected victim statement
have a look at it again
yes victim statement is on chief
medical is typed is it typed
Right.
right victim statement on chief I was married with Hilaluddin Ahmed on 25/1/2008 according to Muslim customary law the marriage was performed socially and after marriage I started to stay with my husband in my matrimonial house at 6 Mile but the marriage did not run smoothly and after 7 days of marriage my in-laws started to torture me both physically and mentally demanding dowry now this is contradicted by PW2 who says that for about 5 months they were happily married they used abusing words towards me and demanded rupees 2 lakhs for the business of my husband my sister-in-law Sitara and Rasida my husband Hilaluddin and my brother-in-law Aminur Rahman tortured me they tortured me physically and also hurt me mentally by using filthy language thereafter on being compelled my parent paid rupees 2 lakh to my husband now PW2 says that I paid 1 lakh to my daughter and my daughter paid 1 lakh to the Hilaluddin so that is another contradiction thereafter on being but in spite of receiving the said money they did not well behaved with me and my conjugal life was not running smoothly they were asking me for more money for smooth business of my husband and in fact they demanded rupees 5 lakhs from January 25th to the end of May I stayed in my matrimonial house on 28/5/2008 at 1 o'clock at noon in presence of my in-laws my sister-in-law badly beaten me and she even hurt me with keys that is
in
what
presence of my husband
Yes, in presence of my in-laws and in presence of my in-laws, my sister-in-law Rashida badly beaten me, and she even hurt me with keys. That is how the injury on lips had occurred. My husband Hilaluddin also caused me hurt, and other in-laws were also present, but they did not do anything. Earlier, I did not inform.
Can you repeat that statement? My husband?
In present.
My husband Hilaluddin Ahmed also caused me hurt, but she doesn't specify what was the hurt. And other in-laws were also present, but they did not do anything. Now PW3, who is victim's mother, she says in her evidence that husband Hilaluddin was a mute spectator. Earlier, I did not inform my parents about physical and mental torture inflicted upon me on that day. I informed on that day, I informed my parents over phone. Thereafter, I went to my parental house and my father took me to MMC hospital. Well, this is again denied by her father. Her father denies to have taken her to MMC hospital or any doctor at all. I had so many injuries, including bleeding injuries. Thereafter, I did not return to my matrimonial house. Since I was not medically fit, I stayed in my parental house for 2-3 days. I filed the complaint before the women's cell, which was sent to all women PS for registering case. Exhibit 1 is my said complaint, 1 by 1 is my signature. Thereafter, police brought me to the court for recording my statement and I was examined in the court on oath. Exhibit 2 is my statement recorded under 164 CRPC. 2-1 is and 2 are my signature. Police also took me to Panbazar Hospital and doctor once again examined me. I never returned to my in-laws and they also never tried to make any contact. I am graduate. Now in cross she says I am graduate in arts. I know all the facts stated in my FIR. My marriage was solemnized on 25th January 2008. It is true that in my FIR I wrote that I had married the accused about 3 months back. The elder sister-in-law Sitara and second sister-in-law Rashida and my brother-in-law Aminur and my husband tortured me. In my FIR, it is written that my husband, along with his father Jalaluddin and his sister Rashida, her husband Aminur and Sitara, together induced my husband for demanding rupees 2 lakhs as dowry. It is true that I did not mention in my FIR that they also tortured me equally. I did not specifically mention from whom my husband Hilaluddin demanded money, but obviously from me. My parent paid 2 lakhs to my husband. My father is a retired government servant. He was working in Department of Agriculture as a clerk. Later on, the witness stated that she paid 1 lakh rupee from her own savings and rupees 1 lakh was paid by her parent. It is true that in my FIR as well as in my examination in chief, I stated that my parent paid rupees 2 lakhs. I was going to tuition prior to my marriage and from that I saved my income. I also sold some of my jewelry for collecting rupees 1 lakh. I sold the jewelry to Messrs so-and-so at Fancy Bazaar. On the middle of February 2008, I sold my jewelry to so-and-so at Fancy Bazaar. I do not remember whether they issued receipt for selling jewelry. The incident took place on 28th of May 2008. My parents came to my in-laws house at about 1 o'clock at noon and they took me from there. Now, incident happening on 1 o'clock, she informing her parents at Machkwa even if it is at 1 o'clock, the parents cannot reach the place of occurrence at 1 o'clock on the same day. And her father has denied that he had even gone for bringing her back. My parental house is situated at Machkwa. At least 20-30 minutes takes for going to 6 miles from Machkwa. On the way to my parents' house, I was taken to MNC Hospital, Panbazar. I was not feeling well. I was beaten badly, so I took rest for 2-3 days and thereafter I lodged a FIR. After the marriage, we went to Kashmir for honeymoon in the month of February at my own cost. Now, this is the reason whether she might have exchanged the gold to get the money. We went to Kashmir by air. We also came back by air. We stay in Kashmir for 7-8 days. My father-in-law is Jalaluddin Ahmed. My husband is a businessman. My father-in-law was not doing anything. Both the sisters-in-law, as I stated in my FIR, are married. They are staying in 6 Mile area in separate house. We did not develop any conjugal relationship after our marriage. I did not file any case for restoration of marriage. Now I am staying at Delhi and studying in in Montessori school. My parents might have stated that my husband demanded rupees 2 lakh for his business purpose and paid rupees 1 lakh to him. In my FIR, I mentioned the money was demanded as dowry. I did not mention in my FIR that the money was sought for business. I specifically mentioned that the demand was made for dowry. It is not a fact that the narration made in the FIR is concocted, not a fact that my husband never demanded any dowry, not a fact that my parents did not pay any money to my husband, not a fact that I did not pay any money to my husband by selling any jewelry. It is also not a fact that he never demanded rupees 5 lakh from me. So these are the evidence of 2 and 3. I'm sorry, 1 and 2. Three evidence of 3 is it is handwritten and it's very difficult to read.
Is it reflected in the trial court order?
It is somehow reproduced.
Is a daughter married her. Yes, demanded money.
And the two defense evidences, they are also their evidence is also written by hand and is very difficult. One DW, it is somewhat legible. DW1, he is a businessman in the locality, Abdul Samad. He says, "Moi Asami Hilalor hoi hakki dibo ahisu. Mor lora hoy 8 sonot lorar oporot gosor gosoria goski di dil boari mor soalir nonod hoy." The informant is sister-in-law of his daughter. That is, in a way, they are otherwise related. The wife's the daughter's sister-in-law. Joa 28/5 তাৰিখে মই ঘৰত আছিলো, দুজনৰ মাজত কোনো ঘটনা হোৱা নাছিল। 2008 বিয়া হৈছিল। বিয়াৰ 4 মাহ পাছত ছোৱালী ঘৰ এৰি গুচি যায়। ছোৱালীৰ মাক দেউতাক আহি লৈ যায়। ছোৱালী 2 দিনৰ পাছত অহাৰ কথা আছিল, কিন্তু 1 সপ্তাহ পাছত পুলিচ যায়। Now there is something illegible. Lora ছোৱালীৰ কিবা টকা পঠাইছিলো, something like this. Now cross by prosecution, মই খেতি কৰো। সময় নিজৰ ঘৰ মাক দেউতাকো এগ্ৰিকালচাৰ ডিপাৰ্টমেণ্টত কাম কৰিছিল। 2008 নাই 2008 লৰা কাঠৰ দোকান চলাই আছিল। আমি কোনো টাকা পয়সা লোৱা নাই। এটা তো পিছনের পাতার রিফ্লেকশন। এটা রিফ্লেকশন, এটা উল্টা দিকের তো। And PW2 is আইনুল হক। মই আসামীৰ হৈ সাক্ষ্য দিব আহিছো। আসামীৰ ঘৰৰ লগত মই ঘৰ ভাড়া লৈ আছো। তছলিমা আসামীৰ পত্নী হয় আৰু মই চিনি পাওঁ। মই স্বামী স্ত্ৰীৰ মাজত কোনো কাজিয়া হোৱা দেখা নাই। 2008 যোৱা সময়ত 8 হোৱা সময়ত কোনো ঘটনা হোৱা নাই। 28 মেত কোনো মাৰপিট হোৱা নাই। ক্ৰছ he is eligible. So practically, my lord, it is the evidence of PW 1 and 2, or for that matter, 3, that will require an examination. And if that is viewed, my lord, the PW 3 has also said in her testimony, I mean, there the contradictions to the extent that as to when she visited the place of occurrence, who accompanied her in taking the victim from the matrimonial home to the parental house, and that they are not, she says that I went to the victim's house, my daughter's house, along with 2 of my nephews. These nephews were also not examined.
Could have been examined. They could have been examined. Anyway.
They were not
There's a
examined.
164 statement according to the judgment. Is it available there?
164 statement has been exhibited as Exhibit 2. As Exhibit 2.
During the trial?
But I could not locate it in this particular record.
Because that we could cross check, you know, the consistency of our narration.
Yes. Now, in the 161 statement, the PW.
Sorry to interrupt you. Did anyone appear on her behalf ever? Or
No,
never appeared.
no.
But she was noticed.
She was noticed. She is the respondent number 2.
Yes.
Yes, she was noticed, but she has not appeared. But therefore, Miller, at the beginning, I said that perhaps, Miller, 2012, she was already in Delhi, pursuing some better course in life. Maybe she has lost interest in this matter.
Very bitter. Respond number 2 after services. That appears.
The cross-examination of PW3 is very lengthy, running into several pages, but it is a bit difficult to. No. Sorry, my lord, I have a matter 47, item number 14. Since your lordship are taking full hearing, my lord, I have doubt, my lord, with the
You want to do that matter? Which matter?
Matter 47, last occasion also, my lord, prior to my lord, his vacation, your lordship did not get time.
I was planning to take order matters from 4 to 4:30, but forgot to tell the registry. Probably tomorrow or day after, I will take. I'll tell them, reflect in the cost list. Anyway.
There were.
It's a very old matter actually, so he also.
Yes. There were reminders sent, my lord, thereafter. This has come in the name of LCR, but this is practically the appeal memo filed before the appellate court. The records of trial is not here. And your lordship will kindly see 2020, another order, last order was passed in the year 2020, calling for the records. Thereafter, this much has come. So 164, 161, nothing is.
164, 161 will not use, but 164.
164 is also not available in this record. Because this is practically what I find is the appeal memo filed before the first appellate court.
It was the GR record actually.
Yes.
The GR record. It was.
That has not come. So that's all, my lord. Now, looking into the attending facts and circumstances, so many years have passed by. Your lordship can consider also, apart from the discrepancies and all, the SI.
Suppose it is upheld, then what did you submit on the sentence?
Suppose if it is upheld, my lord, I would say, my lord, they should be extended the benefit of probation. Because otherwise, I am also not sure whether this man is still alive or not. Because I tried.
Criminal matter may not be. Will it be permissible to extend probation?
Yeah, otherwise, all that it appears from record, it's a singular incident. It's a singular incident. Although she says that there were many incidents right from day 7 of marriage, my lord, but there is no specifics.
Singular incident of assault.
Yes, although she says that there were incidents of assault, I did not tell it to anyone, but these are very, very general in this sense, without any specifics. Because if you are alleging assault by so many persons, at least some particularity is necessary. Because unless the particularity is given, well, it will be difficult to complete the offense so far as a particular person is concerned. So that is not there. It's a general omnibus statement that I was tortured. And her father says that for the first 5 months, everything was fine. It was only on 28th of May that something had happened.
But she said that after 7 days it started.
Yes, she says that after 7 days. Her father says after 5 months. Now, so far as after 7 days is concerned, that period is also solitary statement that I was tortured. But what kind of a torture, mental, physical? And if you have sustained some injury or something, there is nothing. Even she says that on 28th of May, when she was going back home, my parental home, in between she went to MMC and she got herself medically examined, and thereafter she took rest for 3 days and then lodged the FIR. But that aspect of the matter has also not been brought to the notice of the court. If she had really sustained some injuries, then it could have been specifically corroborated during the trial. Now, and the kind of injury in the evidence she says that Rashida threw a key ring on me and I sustained injury on my lips. But on 31st, when she was examined at the instance of police, there was no injury on her lips. The injury was on nasal bridge, forehead and sternum. These are the 3 injuries. And nobody knows whether in between 28th and 31st, she had some fall or some accident or something.
So anyway, this is your summation.
Lordship, on 31/5/8, he was examined by the doctor. And Lordship, the injuries were about 3-4 days old.
She was examined on
31st.
31/5/2008 by the doctor. And Lordship,
3-4 days old.
3-4 days old. And the incident occurred on 28/5/2008, Lordship.
Right.
Some contradictions are there, Lordship. 164 is not there.
164 would have been helpful.
Yes, no.
But it's better to dispose it off, right? Again, call for the 164. God knows whether they will find it or not also. This is the value of time, everything.
Well, 5 years back, Milord, the last reminder was issued, then this thing has come. And this is also not the GR record, Milord. It's a record of the criminal appeal.
Last order was in 3/6/2020.
Yes.
So about 5.5 years.
5.5 years. Thereafter also
It was
only
got
this
listed after 5.5 years. So something about it. This much one. Just, yeah, just few lines. Then, see, that's it. No, it will not be possible. I'll have to reserve it, but still, few lines. Which I'll submissions at least I can dictate. Yeah. Where to be? Just a minute. If you have some urgent work, you can leave be there.
No, no, I can.
Just I will not be able to complete just a few. Invoking the revisional restriction under section 397/401 CRPC within bracket as it existed that the two petitioners here, namely so and so, are seeking interference with the judgment and order dated 18/1/2016 passed by learned additional session judge number 4, Kamrup M. Guwahati, in criminal appeal number 72 of 2015, whereby the learned appellate court was pleased to uphold the judgment and order dated 24/6/2015 passed by the learned CJM Kamrup M in GR case number 3951 of 2008 whereby the petitioners as accused were convicted under 498A IPC and sentenced to undergo simple imprisonment for 3 months each and pay a fine of ₹5,000 each within bracket ID undergo SI for 1 month each. The facts in brief are that on ... full stop, the informant count victim woman Tasneem Ahmed lodged an FIR before the Oluman Police Station, Guwahati, alleging that after her marriage to the petitioner number 1, Hilaluddin Ahmed, he and his family members had subjected her to physical and mental torture upon demand of money, and despite payment of ₹2 lakhs, such ill treatment continued. Full stop. She further alleged that on 28/5/2008, she was assaulted by her husband and family members, causing injuries. Full stop. The case was registered upon receipt of the FIR. The PS case, Oluman PS case number so and so of 2008 was registered under 498A34 IPC. An investigation started, which resulted in a charge sheet with the corresponding GR being GR number 3951 of 2008. Trial commenced during which the prosecution examined 5 witnesses, including the informant / victim, her parents, doctor, and IO. The defense examined 2 witnesses, including the father of the husband. First, upon completion of trial, conviction and sentence was passed as mentioned above. Though the same was taken up in appeal before the Sessions Court, but the appeal came to be dismissed, giving rise to the present revision. The scan case record as called for was received. Scan, the original case record This is the original case report.
No, this is the appeal memo of the original of the order sheet of the order sheets of the appeal. Appeal.
Yes, yes.
Rest are all photocopies.
The case record, partly scanned, partly in original, has been received from the learned appellate court. Appellate court. Actually, that is why actually we need the appellate, after the appellate judgment, it is sent back to the trial court.
Yes.
So trial court has everything actually.
Actually, it should have come from the trial
That
court.
is better. They can send everything. Though, as reflected in the order dated 7/9/2017, the respond number 2/informant was duly noticed, but he did not choose to appear. And today also none appears on her behalf. Learned counsel, portal if you heard submits that there are several contradictions in the testimony of the PW 1 and 2 and 3, who are the informant and her parents. And they also happen to be interested witnesses. It is submitted by the learned counsel that though the informant as PW 1 is stated about examination, her medical examination at MMC hospital, but her father has not stated regarding the same. Full stop. It is also submitted that the petitioner, the PW 1/informant, was stated about paying ₹2 lakhs to the husband family, to the husband and his family. But in the testimony of her father, it is revealed that he paid ₹1 lakh to her even before the harassment / torture had started, and that the same was supposedly sought for by her for investments. Full stop. It is submitted by the learned counsel that there are also contradictions with regard to the time when her parents had supposedly arrived at the place of occurrence to take her back, vis-a-vis the time of 1 p.m. that she indicated about informing her parents first. Moreover, the two cousins who were stated to have accompanied to the matrimonial home to bring her back were not examined during the trial. Full stop. It is submitted by the petitioner counsel that though the alleged incident of assault took place on 28/5/2008, but her medical examination was on 31/5/2008, and in the intervening period, it is not clear as to how she sustained those injuries, and as to whether she sustained such injuries due to reasons other than any assault attributed to the petitioner side. So the petitioner counsel submits that due to the contradictions that have emerged in the testimony of the family members are of a material nature, and therefore there is some doubt on the prosecution story. and therefore praised for allowing this revision. On the other hand, and thus learned additional PT submits that the learned additional PP has submits that it is reflected by the learned court that the injuries at the time of examination. I'm getting old. Were 3-4 days old, and which tallies with the time span between the date of incident on 28/5/2008 and the date of examination on 31/5/2008. I'll stop. I have perused the revision petitions, the impugned appellate judgment as well as the judgment of the learned trial court, the depositions before the learned court below, and other relevant materials. Reserved.
Obligement.
I'll try to give it this week only. Yeah, provide one. But very good. We have a lot of time constraint beyond court also. And this is filed, so some work has to be done here. Anyway, Mr. Chair, you want to do now? What should we do now? 10 minutes there. So tomorrow, say, let's see what kind of list comes. Otherwise, I have a plan. I had said it last year. I have a plan that from 4 to 4:30, I'll take dedicated order matters. I'll try to, because it has to be mentioned in the cause list, so that the councils don't have confusion. So that at least we can touch the order. That is how we have to divide actually. Time slots, if we can divide, then we can take things parallel. Bail we complete, then admission we touch a few, and orders we touch a few like that. Yeah.
My lord, my item is 24, my lord.
We did 24, 25. Anybody is there? Just
My lord, I am 24, my lord.
24.
Yes, my lord. But the matter has already been amicably settled by the parties, my lord. So subsequently, the
Very
both
old
the
also,
petitioner
18.
filed joint petition, my lord, joint affidavit, my lord.
Okay.
So it may be, my lord, disposed of
Wash.
on compromise, my lord.
On compromise.
Yes, my lord.
Let me see the file. Just. Mr. Chauhan, your matter is what?
Well, it's 47, my lord, criminal appeal, my
Appeal
lord.
bail.
The petition, 2 appellants are there. They are in jail, my lord, 3 years punishment, my
I
lord.
see.
In 3 years punishment, my lord, Honorable High Court grant bail, my lord. That is my case.
I'll see how I can accommodate you. Maybe tomorrow at 2 or something. Let's see. Don't worry. Because this non-bail order matters, no, they don't take time. They take only bail matters take some time. Yeah, last order it was reflected also. Talk of compromises.
Yes, my lord. Subsequently, my lord,
Yeah.
additional affidavit was filed, my lord. Joint affidavit, my lord,
Okay.
which is tagged, that is what, my lord, as A. My lord, at page, my lord, 84, my lord, on the basis of memorandum of understanding, my lord, MOU was executed between the parties, my lord. So both the parties wanted to.
84.
Yes, my lord. 84, my lord.
Yeah, file.
The additional. They are cousins brother, my lord. So, my lord, they have amicably settled the matter, my lord. So initially we have filed, the petitioner filed the petition under so 482, my lord. Subsequently, they have amicably settled. So subsequently we have filed
Only
the joint.
problem is that there's nobody on the other side. Of course, I trust you, but the thing is that it would have
Yes,
been
sir.
better if somebody. Did they appear?
Yes, they
had
appeared,
appeared.
but today.
Today is not there. So if you can inform them, we can take it up tomorrow.
I can inform them, madam.
Tomorrow, day after tomorrow, I can,
No.
the motion matter.
Then, my lord, it may be taken after vacation, my lord, then. If, my lord, otherwise, my lord, joint affidavit is filed, my lord.
Yeah, joint affidavit
Yes.
is fine. Why keep it for vacation? You can dispose it off. End of
Maybe
the matter,
dispose
it will
of
be. What do you say?
Lordship can dispose of.
Dispose of, but
Or joint
any,
petition is there.
don't we need a confirmation from the other side? From the other side.
Yes. S. Ahmed is there.
As I said, no, of course I
Yes,
trust
yes,
you.
my lord.
The thing
Earlier
is that,
also they have not appeared.
but procedure.
Yes, yes.
Procedure, it will be better in removal proceedings.
Lordship will fix tomorrow.
Yeah, that's what I say. Yeah, are you, do you know who's appearing for
One
his,
S. Ahmed and
for
F.
your cousin
Chaudhary,
brother?
it is reflected.
If you can contact him, then do it. Tomorrow we take up at 2 o'clock. That matter also we can take up at 2 o'clock. And both matters we can finish.
I can inform them, but do not have the communication number, madam.
Number.
That is the problem.
Who's appearing? What's the name?
S. Ahmed and F. Chaudhary.
Earlier also, my lord, he didn't
Yes,
appear,
Ahmed.
madam.
He appeared today also. Yeah.
Nice.
Yes, Ahmed is here. They can give you the number. Take a chance tomorrow. Let us take a chance tomorrow. Huh? Tomorrow at 2 o'clock. Huh? We'll take a chance. Try to get the number. Take their help. And if you can get, if he comes, all he has to do is say that yes,
Yes, sir.
I confirm the affidavit. Then by a short order, I dispose it. Eh?
Pleasure, lord.
Why keep it for after the vacation? Tomorrow at 2. Your matter tomorrow, I'll take it up at 2 o'clock tomorrow. Tomorrow at 2 o'clock.
47, I think.
47, tomorrow at 2 o'clock. Because it has come for several days, no?
Yes, yes.
It's come for several days. The matter 47, it is submitted that the matter has been listed on several occasions, but it has not reached place for fixing a matter tomorrow. This is the matter tomorrow at 2.
25 may also.
25, yes, tell me what is the number. Tomorrow at 2. We'll take it. Tomorrow, what is 25?
25 and for the response number.
Yes, yes.
That may also come up tomorrow.
Tomorrow, because what is this matter? Will you have to go inside or?
Man.
We have to,
go inside.
and then. Except for the fact that.
Then any other day convenient days.
Vacation officer.
Then
After vacation, Lordship.
Oh, this will require a hearing, I think.
This study,
Against conviction.
27.
against condition.
Or then it be after vacation.
Madam, in the first week of February, madam.
First week of February.
First week of
4th
February.
of February.
Madam.
First week of February, date to be fixed by. registrar? On a date to be fixed by.
Fourth of-
Or should I fix a date?
4th
For
of February.
February.
Lordship.
4th of February. Okay, 4th. 4th, done.
It is lawsuit. Item number 49. Lawsuit.
Order matters.
Yes, sir. In this case, may I permit to take steps upon the respondent number 2, lawsuits?
Steps.
Steps. Due to miscommunication, I could not take steps
Okay.
upon the respondent.
49.
And then
Press steps upon respond
number
number.
2. And then whether case day was called for.
Case
Case day
day
was called for. But the case day isn't available in the 49.
CD not
is
received.
there as call for not received, issue requisition for the same. List the matter after. List the matter. You can please suggest a date.
On 12th of February. Oh,
I could hear.
okay. On Lordship, 6th of February, Lordship.
6-2.
6th.
Any interim order? No.
No, lawsuit.
Okay. And the criminal order appeals maybe, they must be, why have they come for? Just give apni date did you know? Criminal orders. I do not know why they have come. Anything else? You want to make any mention?
No, I've already mentioned.
Okay. Yes, sir.
Lordship, 43, item 43 already appeal is admitted, my lordship.
Appeal is admitted.
And CRE has been received.
Okay.
So
Fixed for hearing.
Fixed for hearing. my
Hearing,
lordship.
yes. Like that mostly it's there. It appears that the matter is ready for hearing. We posted for hearing in February, no? You can suggest a date.
February, Lordship.
Second week of February, you can suggest a date.
On 12th February, Lordship.
12/2.
God bless you.
তাকে criminal appeal থেকে খুব বেশি late meeting. Criminal appeals, we can give a date maybe after
Yes,
reopening, then maybe because some of them may be ready for hearing like this.
Lordship.
Okay.